Good afternoon and welcome to the Appellate Division, First Department. I will commence with the calendar call. Please pay attention for your name. People v. Filberto Calyx.
Arthur Hopkirk, attorney for Filberto Calyx, the appellant.
You've been granted 4 and 1. Welcome. Mr. Myers, respondent.
Yes, Your Honor. Robert Myers, present.
Good afternoon. You've been granted 4 minutes. Marks versus 79th Street. Mr. Levine.
Yes, Your Honor. Jason Levine for the plaintiff appellant.
Good afternoon. You've been granted 5 and 1.
Thank you, Your Honor.
You're welcome. Respondent 79th Street, Mr. Weinberg.
Good afternoon, Your Honor. Seth Weinberg for 79th Street.
Good afternoon. You've been granted 3 minutes.
Thank you, Your Honor.
Respondent New 5679 IG Associates.
Yes, good afternoon.
Good afternoon. Mr. Marr, you've been granted 3 minutes. If everyone who is not speaking could place their, put the mute button on, it'll help reduce the feedback. Thank you. H. Mary versus Cedric is submitted. Tercios versus New York City Health and Hospitals, Mr. Kessler.
Yes, Your Honor, I apologize. I am here.
Good afternoon. 5 and 1. Ms. Friedman.
Yes, good afternoon, Your Honor.
Good
I
afternoon.
am here, appearing for defendant respondent.
Thank you. You've been granted 5 minutes.
Thank you.
Bain versus 50 West Development. Mr. Isaacs for appellant.
Yes, Your Honor, I'm here.
Good afternoon. You've been
Good afternoon.
granted 5 and 2.
Thank you, Your Honor.
For respondent, Mr. Herzler. Have I said that correctly?
Yes, you did, Your Honor. This is Nicholas Herzler for the defendants.
Wonderful. You've been granted 5 and 2 as well, as I understand you have a cross appeal. Am I correct?
That is correct. Thanks, Judge.
Thank you. People versus Preston Norales. Ms. Moran.
Yes, Your Honor.
Good afternoon. You've been granted 4 minutes. For the respondent, Mr. Commodore.
Yes, Your Honor. John Commodore for the Office of the Bronx County District Attorney.
Good afternoon. You've been granted 4 minutes.
Thank you, Your Honor.
Matkins versus 22 Little. For appellant, Mr. Persman.
Yes, Your Honor. Good afternoon.
Good afternoon. You've been granted 7 and 2. Respondent 22 Little West, Ms. Finocchio.
Yes, Your Honor. Carol Finocchio for defendants, respondents, appellants, and it's my understanding 4 minutes.
That's correct. Welcome. Mr. Walsh for Hanco Welding.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes as well.
Thank you, Your Honor.
For respondent Northeast Serve Interiors, Ms. Matera.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes.
Thank you.
Wilkes versus New York City is submitted. Jacoby versus Syracuse, New York. Appellant's counsel, Mr. Confucion, I believe I heard you pronounce it.
It's correct, Your Honor. Good afternoon.
Very good. Good afternoon. You've been granted 4 and 1.
Thank you.
Mr. Whitford for respondent.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4 minutes. People versus Tashawn Burrows is submitted. Charlemagne versus Aquatic Recreational. For appellants, Annette Hassapidis.
Yes, Your Honor.
Good afternoon.
Good afternoon.
You've been granted 5 and 2.
Thank you, Your Honor.
For respondent Aquatic Recreational, Ms. Henderson.
Good afternoon, Your Honor.
Good afternoon. You've been granted 4. For Rose Associates, Ms. McDougall.
Good morning. Good afternoon, Your Honor.
Good afternoon. You've been granted 4.
Thank you.
National Health versus Liberty Mutual. Appellant Liberty Mutual. I believe there is a pro hoc vici application. I will hear from New York Counsel.
Good afternoon. This is New York Counsel Todd Rosenbaum on behalf of Liberty Mutual Insurance Company and Arlington Insurance Company Limited. My colleague Nicholas Cram has preliminarily been admitted pro hoc vice to argue, and we'd like to make that application formally at this time.
Your application is granted. Mr. Cram?
Good afternoon, Your Honor. Thank you.
Good afternoon. Welcome.
Thank you.
Appellant Arch Insurance. By the
Yes,
way,
Your
you've
Honor.
been granted 5 minutes.
Yes, Your Honor. Thank you.
Mr. Lewin for Arch Insurance.
Yes, Your Honor. I'm
Good
appearing.
afternoon.
Good afternoon.
And you've been granted 5 minutes as well.
Thank you, Your Honor.
Appellant Prism.
Yes, Catherine Harrison here for Prism.
Good afternoon. You've been granted 5 minutes.
Thank you, Your Honor.
And for Respondent National Health, Mr. Glatt.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 10 minutes.
Thank you, Your Honor.
U.S. Bank versus Moran. I believe we only have the respondent.
Yes.
Mr. Abramson, are you here?
Good afternoon, Your Honor. Keith Abramson with Franco Lambert on behalf of the respondent.
Good afternoon. Welcome, and you have 5 minutes.
Thank you.
Pastorino versus City of New York.
Good afternoon, Your Honor. Tim Schweitzer on behalf of Appellant Joseph Pastorino.
Good afternoon. You've been granted 7 and 3.
Thank you,
Respondent City.
Patrick Lawless for City of New York.
Good afternoon. You've been granted 5 minutes. Respondent Commodore. Mr. Crow.
Good afternoon, Judge. Good afternoon, Judge. Vincent Crow for Respondent Appellant Commodore Maintenance.
You've been granted 5 minutes. Respondent Ocean Marine.
Roland Vitanza from Kaufman Dulwich and Volek.
Good afternoon. You've been granted 5 minutes. Montefiore Medical versus Empire Health Choice. I believe we have another pro hoc vici application.
Yes, Robin Muir for the appellant, and we have an application to admit my colleague Aaron Chapman, pro hoc vici.
Your application is granted, and Ms. Muir, it would be good if you join the call a little earlier than 2 minutes before time. Okay?
Understandable. My apologies.
No problem. Ms. Chapman, welcome, and you have been granted 5 and 2.
Thank you.
Respondent, Michael Keene.
Good afternoon, Michael Keene with the firm of Garfunkel Wild.
Good afternoon. You have been granted 5 minutes, and the case of J.P. Morgan Chase versus Waletsky is submitted. First case on the calendar, People versus Filiberto Calyx. Mr. Hopkirk, please. You have
Yes.
4 minutes. You may proceed.
Okay. Good afternoon, Your Honors, and may it please the court. My name's Arthur Hopkirk, and I represent Filiberto Calyx. The SOAR hearing court erred in assessing points for appellant's alleged infliction of physical injury and for his alleged failure to accept responsibility based upon his refusal to participate in sex offender treatment. With respect to the points for physical injury, the prosecutor relies on a medical examination of the complainant that occurred more than 8.5 months after the last crime that my client was charged with committing.
Counselor, this is Judge Singh. Your argument, as I understand it, someone else could have committed an additional crime, presumably, right?
That's correct, Your Honor.
Now, what evidence, other than the gap in time, supports that theory?
It's primarily the gap in time, as well as the fact that the burden of proof is on the people to prove that my client caused the physical injury rather than someone or something else. And we suggest that given the gap in time, they can't meet their burden of proof by a relatively high standard of clear and convincing evidence. One simply can't know whether the healed injuries that the doctor saw so long after the crimes were caused by my client or someone else. And as I say, that doesn't meet their burden of proof. Notably, my client was not charged, and this also goes to what Justice Singh was asking. My client was not charged with any crime that has physical injury as an element, and the Board of Examiners of Sex Offenders, following its own guidelines, did not score points for this factor because they say that the fact that somebody hasn't been indicted for something is some evidence that creating a presumption that didn't occur. If my client in fact was responsible for causing physical injury, the prosecution could have met their burden of proof by introducing a sworn statement, for example, that my client was the only person that the complainant had sex with prior to the discovery of the healed injuries, or that the complainants suffered substantial pain at the time of the crimes, but they did.
Counsel, this is Justice Kennedy, and what I'd like to know is how do you address the doctor's testimony that indicated that this 12-year-old victim, that the injuries were caused by repeated penetrating genital injury with force? Can you address that?
Certainly, Your Honor. Even if one accepts the doctor's testimony on that, that doesn't mean that the injuries were caused by my client being the one who caused those injuries. It could have been somebody else who had sex with the complainant. Given the gap in time there, we don't really know who might have been responsible for what the doctor saw.
Speculative counselors to say that
He was the stepfather. Am I correct? He was the stepfather? He was the stepfather, right?
Yes, he was, Your Honor. If I can move on to the second.
Unfortunately, you are out of time.
Oh, okay. All right.
Okay. Mr. Myers, you have 4 minutes.
Thank you, Your Honor. Robert Myers for the Office of Darcel Clark. Good afternoon, and may it please the court. This court should affirm the SORA court's determination assessing 95 points to defendant under the risk assessment instrument and designating him a level 2 sex offender.
Was there any valid proffer to suggest that this child was having sex with other people other than the man, her stepfather, who was raping her?
No,
Is
Your
there
Honor.
any evidence at all?
No, Your Honor. Nothing in the record whatsoever suggests that this child was being victimized by anyone other than her 38-year-old stepfather, the defendant in this case. Again, direct evidence from the medical testimony of Dr. Shakat at trial proved that the victim's injuries were consistent with the rape that she suffered from a grown man, 38 years old, raping a 12-year-old child. There's no evidence and nothing beyond speculation suggesting that anyone else victimized this 12-year-old child.
Right. There was no evidence at trial that suggested that this was a highly promiscuous 12-year-old that was going around having sex with all her junior high school friends, for instance.
No, Your Honor. Nothing whatsoever in the record suggested anything like that, Your Honor. The SORA court made its proper assessment of 15 points under Factor 1 of the RAI in line with the Dr. Shakat's testimony for inflicting physical injury on the victim. I do also want to address the second point that the SORA court did properly assess defendant 15 points under Factor 12 of the RAI for his refusal to participate in sex offender treatment and not accepting responsibility. The totality of the circumstances here demonstrate defendant's failure to accept responsibility, and it remains undisputed defendant has never completed any kind of sex offender treatment or counseling, and the record suggests that there is no point, not before his sentencing, in the pre-sentencing report, at his sentencing, or at any point thereafter, despite numerous opportunities to participate in treatment, that defendant has ever expressed any kind of remorse or accepted responsibility in any way at any point. This court should affirm the SOAR court's determination assessing defendant 95 points under the risk assessment instrument and designating him a level 2 sex offender.
Mr.
Please
Myers,
affirm.
Judge Singh, you argue, and I'm not sure if you're really pushing that argument, that since the defendant has been deported, that the appeal should be held in abeyance or dismissed without prejudice. Is that still your office's position in light of our case law?
And yes, Your Honor, as you've noted, my office's position is to invite this court to revisit its precedent in People v. Edwards, along with its progeny. But that is correct. I do rest on my brief to that extent.
Okay, thank you.
Thank you.
Thank you.
Mr. Hopkirk, you have 1 minute.
Okay, yeah. I think we already discussed that the people are shifting the burden of proof. It's not our burden to prove that somebody else was having sex with the complainant. It's
but for you to assert that, Mr. Hopkirk, there's got to be some factual basis. And if it wasn't asserted at trial, it seems to me this is an inappropriate place to begin doing so.
Well, it couldn't have been asserted at trial because of the rape shield law, but the burden of proof is on them. Anyway, can I briefly address the second part of this, which is people are misrepresenting what People versus Ford says, quoting a sentence they leave out of their brief. Quote, refusal contemplates an intentional explicit rejection of what's being offered. And I'd emphasize the Court of Appeals use of intentional. Here, my client used a Spanish interpreter at both his trial and his SOAR hearing, yet the forms that the people rely on to show that my client supposedly intentionally refused sex offender treatment are written in English. And without evidence that the forms were translated, one can't prove by clear and convincing evidence that someone intentionally refused something based upon their signature on forms in a language that they're not literate in. This court's decisions in People versus Bueno and People versus Rosario, which respondent ignores in their brief, support my client's position.
During the SOAR hearing, did your client testify that at no time he was offered sex offender treatment? Is that what you're saying?
No.
That's what the SOAR hearing shows?
No, first of all, that would once again shift the burden of proof. Secondly, the submission.
My question was whether counsel, my question was whether your client asserts as a part of his SOAR hearing that there should be no points assessed for a failure to participate in treatment because he was never offered any? Or is the argument, the technical argument, that there's no proof of it because he signed a form written in English?
I wouldn't describe it as a technical argument, but it's more the latter than the former. Okay. The forms, it's putting the cart ahead of the horse, I would suggest, because until he has validly signed a form that he can understand, the question of whether the prison offers sex offender treatment, you don't get to that until he's been offered the opportunity and declined it in a language that he can understand. And given the lifelong consequences of SOAR registration in a multilingual country, it's simply important that before refusal forms are used to someone's detriment, there be proof that those forms either have been provided in the native language of someone who used an interpreter at their trial, as happened here and at the SOAR hearing, or then interpreter read the forms to the inmate before he or she was asked to sign them. Since there's no such proof here.
I appreciate your argument, and obviously as a Latina woman, certainly understand exactly what your argument is. Thank you. You have a good day.
Same to the court. Thank you.
Okay. Marks versus 79th Street. Mr. Levine, you have 5 minutes.
Thank you, Your Honor. Thank you, Your Honor. Jason Levine for the plaintiff appellant. We submit that the defendant's motion for summary judgment should have been denied upon the ground that the defendants did not establish in the first instance that the sidewalk defect on which plaintiff fell was trivial on the date of the accident. the defendants relied on the affidavit of their expert, Mr. Yarmus, whose affidavit was based on an inspection over 3.5 years after the accident. And during that inspection, he made a finding that the height differential between the sidewalk slabs was 7/16 of an inch. However, there's no other proof in the record submitted in initial support of the defendant's motions that this was the condition on the date of the plaintiff's accident, only on the date of his inspection 3.5 years later.
So this is Judge Singh. Your expert says that there was it was a 1/4 inch wide gap.
He determined, Mr. Silverman, that the sidewalk joint between the two flags was a quarter
inch wide, several inches long, several inches.
Right, 1.25 inch wide and over 1 inch deep.
It's 1 1/4 or 1/4 inch?
1 1/4 wide.
1 1/4?
Yes, and over an inch deep. But weaving back in, the motion court determined that 2 photographs that were submitted by the defendant with Yarmus's affidavit showed, quote, no discernible height differential between the subject slabs. However, again, this weaves back to my prior point, is that the photographs were taken on the date of Mr. Yarmus's inspection, which was 3.5 years after the accident. And the defendant's own proof in support of their motions itself raises an issue of fact, whether or not when the repairs were done to that sidewalk, the testimony of the 2 building superintendents, they both testified that no repairs were made after the plaintiff's fall. This, however, conflicted with the plaintiff's deposition testimony that, in fact, the sidewalk was repaired after she fell at some point when the sidewalk shed was taken down. And indeed, Mr. Yarmus himself points out that the sidewalk was in fact sealed and repaired, but he couldn't establish and he did not know when that was done. We would submit in the first instance, in the absence of any conclusive evidence of the condition of the sidewalk on the date of plaintiff's fall, the defendants could not meet their initial burden. And the court erred in concluding that the defect was trivial as a matter of law. And I would also point out, Your Honors, I just want to point to in connection with the defendant's burden, to a case that actually the court handed down last week. I provided a copy this morning to defense counsel of a case called Trinidad against Katsimatidis, slip opinion 2021-00047. It supports our argument in connection with the defendant's failure to meet their initial burden. Additionally, in the alternative, we would submit, just following up on Justice Singh's pointing out Mr. Silverman's affidavit, that Mr. Silverman's affidavit did in fact raise an issue of fact as to whether the sidewalk constituted a dangerous and defective condition on the day of the plaintiff's fall.
Does the BP permit that theory of liability?
Yes, Your Honor. I would submit that, the court, in rejecting Mr. Silverman's opinions, made an erroneous determination that the plaintiff's theory of liability was limited only to height differential of the 2 sidewalk flags. We would submit neither the complaint, the BP, the supplemental BP, or even for that matter, Mr. Silverman's expert disclosure, so limited plaintiff's theory. The BP and the supplemental BP alleged that there was an uneven, broken, and raised sidewalk, as well as a violation of Administrative Code 19.152. And that code provision is not limited to height differential. There's a separate clause in that code provision that provides where the sidewalk flag contains 1 or more surface defects of 1 inch or greater in all horizontal directions and is 1/2 inch or more in depth, that will constitute a hazard or substantial defect, which, as I pointed out earlier, that falls right in line with what Mr. Silverman found. A 1/4 inch wide defect plus over 1 inch deep.
Okay, you have a minute on rebuttal. Okay.
Thank you, Your Honor.
All right, Mr. Weinberg, you have 3 minutes.
Thank you, Your Honor. Good afternoon, Your Honor. Seth Weinberg with Moran Lilling, the party for 79th Street tenants. I'd like to begin with plaintiff's recitation of his client's testimony about the repairs to the sidewalk. And what she testified to was, number 1, she doesn't know when the repairs were made. And number 2, she said the repairs were all new. The sidewalk was replaced. All of the cement was reinstalled. But if you look at all the photos submitted by both experts, There is not a new sidewalk in any of them. All of these sidewalks have been there for a significant period of time. The photographs, she cannot rely on her testimony and her recollection to get around the photographs, which speak for themselves. So there is no evidence that the sidewalk was repaired after the fall. The only evidence is the testimony from the superintendents that it wasn't. Our client's experts' measurements are 7 1/16 inch height differential, which is—
Mr. Weinberg, this is
Yes.
Judge. So we have two experts, or the experts have competing measurements here. Why doesn't that in itself create an issue of fact? Plaintiff's expert says it's 1 1/4. Yours says it's something less. Shouldn't a jury evaluate that to determine A, whether it's trivial, and whether that was a dangerous condition?
Well, the answer is, Your Honor, plaintiff's expert didn't measure the area where plaintiff fell. So what we have here is plaintiff's expert did a first inspection pre-plaintiff's deposition. And if you look at the photo—
And how many years after the accident did your expert measure the area?
3.5 years, but the point was
let me finish my point. So doesn't that really go to weight in terms of what the plaintiff's expert says and what your expert says, which is classically for the jury to decide as opposed to judges in the appellate division to decide?
If the plaintiff's expert measured the spot where plaintiff actually fell, absolutely, Your Honor. But the issue we have here, if you look at the picture at page 338 of the record, which is where plaintiff circled the defect, she circled the defect in the third sidewalk flag in from the left. There's only 5 sidewalk flags. If you look at the pictures at page 506 of the record, where plaintiff's expert measured, on the top is his second inspection, if you will, which is in the middle of the third flag. On the bottom, where you see the red circle, is in the middle of the second flag. So the measurements he took were of the second sidewalk flag. So we don't have conflicting measurements of the same spot. We have plaintiff measuring one flag, which is different than the one plaintiff identified. We have our expert measuring the one plaintiff identified. So to answer your question shortly, plaintiff's expert can't get on the stand and say there's a true conflict when we're talking about 2 measurements of 2 different spaces.
And you're saying that the plaintiffs agree that you're talking about 2 different spaces?
Plaintiff disagrees with the photo.
Does plaintiff assert that you are wrong about that?
Well, plaintiff does assert I'm wrong, but the court can look at the photographs. The court can look at the photographs and the pictures are what they are. This is not something for a jury to count 3 flags versus 2 flags.
All right. Thank you. You're out of time. Thank you,
Your Honor.
All right. Mr. Marr, you have 3 minutes.
Good afternoon. Thomas Marr from the law firm of Perry Van Etten, Rosansky and Kuttner on behalf of respondents 5679 IG Associates LP. I just want to echo that when plaintiff testified, she identified the cause of her fall as a height differential. Now, it's not uncommon for people's bill of particulars to allege a variety of different things, some which are supported by the facts, some which ultimately aren't supported by the facts. But in this case, the plaintiff was questioned about what caused her accident, and she said that part of the sidewalk was high and the other part was low. So she claimed she tripped because of a height differential. Now, plaintiff's own expert went to the scene and he did not note a height differential in the sidewalk flags in excess of 1/4 inch. And I would submit that if he had found such a height differential, he would have noted it in his report. Rather, he's talking about another condition at another portion of the sidewalk, which is a gap between the flat surfaces of the 2 flags and whether it had been filled in or not with caulking or something of that nature. But significantly, that's not the condition that plaintiff alleges caused her accident. And I would submit that unless plaintiff can prove that a height differential existed and that was the proximate cause of her accident, the fact that there may be other defects in the area, if those defects were an approximate cause of the accident, they can't support this cause of action.
Okay, thank you. Mr. Levine?
Yes,
you have
Your Honor,
1 minute.
thank you. I just want to address finally this issue about where Mr. Silverman inspected and that somehow it's 2 different areas. I would submit that if you compare the photographs The one at page 237, which is the one where the plaintiff circled the area where she fell at her deposition, with the photographs at page 506, it shows that Mr. Silverman examined and inspected the exact same spot. If you, the photo at page 237 shows the support pole to the right of her circle. And then there's a sidewalk joist that runs along to the right side of that support pole. The photo, the second photo, the one underneath the bottom photo, similarly shows the support pole and then the sidewalk joist to the right of that pole. The defendants are claiming that somehow Mr. Silverman inspected the sidewalk by referring to page 237, to the support pole that's closest to the curb where the car is parked. But as you can see, the sidewalk joist that runs next to that pole is to the left of the pole, not to the right. So I think, frankly, this is a red herring that they've raised, which unfortunately the court kind of accepted, when in fact, there's really no dispute here, in our opinion, that Mr. Silverman examined the same spot during his 2 inspections. And unless the court has any further questions, we'll rest on the arguments.
Thank you so much. Have a good day, all. Tercios versus New York City Health and Hospitals Corporation. Mr. Kessler, you have 5 minutes.
Thank you, Your Honor. May it please the court. My name is Mitchell Kessler, representing the appellant. Your Honors, this appeal goes solely to the timeliness of the notice of claim and not to the merits, although the facts are meritorious and compelling. Your Honors, I respectfully submit this is a very clear continuous treatment case. The plaintiff went to Jacobi Medical Center. She was malpracticed by a failure to diagnose her impending stroke. As a result of the stroke, the ambulance took her, not at her choice, but the ambulance's choice, to Montefiore. 1 week in Montefiore, the very day she's discharged, she goes to Jacobi for continuous treatment to correct the condition which the malpractice caused, which falls squarely under both the statute and the case law. Between May 17th.
This is Judge Mendez. Did she go back to Jacobi to treat for a neurological condition, or did she go back for therapy?
Well, I believe the proper answer, Your Honor, is both. In other words, she had many deficits as a result of this stroke, one of which was speech. On the day of the stroke, she couldn't speak at all. And the main therapy that she received at Jacobi Medical Center was speech therapy so that she could speak again. And indeed, her speech has never returned to her completely, but that was a treatment for the sequelae of the malpractice. And Your Honors, between May 17th, 2011 and December 7th, 2011, I count from the record 47 dates that she appeared at or treated at Jacobi Medical Center specifically for her stroke sequelae, all the months.
Judge Singh, how do you distinguish, and it's mostly cases from the Second Department, which hold that post-op care after surgery is not a continuation of course of treatment for the condition which gives rise to the malpractice. Are those cases, should we follow those cases, or is it in your view they're not good law?
Well, my position is that they are good law, that they are compelling and persuasive, but Your Honor, I respectfully submit I am not hanging my hat on the Second Department. Indeed, the Court of Appeals in Borgia said it would be absurd to interrupt corrective efforts to commence a lawsuit. In McDermott, where the plaintiff soon returns to treat for the sequelae of that condition, it cannot seriously be expected to commence a lawsuit where there exists alternatives of seeking corrective treatment. So, Your Honor, I respectfully submit I'm relying on the Court of Appeals and the First Department with a couple of Second Department cases. And indeed, she treated up to and including every single month to December 7th, and the notice of claim was served a week later. It is true I mentioned the case Crow-Pickney, which is Second Department, but I believe it falls directly in line with what the Borgia case holds. In addition, this is a continuous treatment rule case, Your Honors, not a continuous diagnosis case.
So Mr. Kessler, if I may, the plaintiff initially appeared at the emergency room with complaints of headaches and seasonal allergies, correct?
No, Your Honor, respectfully, not correct. The plaintiff appeared with headaches. And indeed, her testimony at her deposition repeatedly was it was the worst headache of her life. What the
So we're
defendant—
on the same page, counsel, because I did say complaints of allergies and headaches. My question is, since we agree on the headaches, the next day she was diagnosed and treated for a stroke. That was at a different hospital, Montefiore, correct?
Yes, Your Honor. However,
and then she returned to Jacoby a week later for post-stroke treatment, correct?
I agree with all of that, Your Honor, except for—
Okay, but stay with me. And when she returned to Jacoby, it was never for a complaint regarding a headache, because that's why she went to the ER.
That is, I respectfully disagree with Your Honor, because what happened was this. She went to Jacoby with the complaint of the worst headache of her life. She never complained of seasonal allergies at Jacoby, because if one were to read her deposition testimony, she testified she didn't have watery eyes. She didn't have anything to do with allergy. What Jacoby wrote in the chart was that she had a history of allergies. They did not write that she had allergies at the time. She went to Jacoby for the worst headache of her life, which should have been more carefully diagnosed and therefore treated as an impending stroke. She then had the stroke. The ambulance took her to Montefiore. She didn't choose Montefiore. When she was done with Montefiore, she went straight back to Jacoby to treat her for the sequelae of the stroke, which falls right in line with Borgia and McDermott. This is
okay. You have a minute on rebuttal. Ms. Friedman, you have 5 minutes.
Yes, thank you, Your Honor. Elizabeth Friedman, I'm appearing for defendant respondent, New York City Health and Hospitals Corporation. Your Honor, we also rely on Court of Appeals cases that are cited in our brief. The Court of Appeals cases are Nykerchuk and also the Allende, and also, Your Honor, Young versus HHC. Your Honor, very simply, a failure to diagnose is not a course of treatment as a matter of law. So here we have an allegation of a failure to diagnose a particular condition. The plaintiff then was discharged from the emergency room at Jacoby on May 10th, 2011, and she then went to a different hospital, Montefiore, the very next day for a diagnosis and treatment of her stroke. She was there until May 17th, at which time she returned to Jacoby on the 17th for rehabilitation. That is for non-medical treatment. It did not have to do with diagnosis and treatment of the stroke. It was to help with the symptoms such as physical therapy, occupational therapy, speech therapy, and not the stroke. The stroke treatment all occurred at Montefiore Hospital. And in fact, she continues to this day to treat with the stroke specialist at Montefiore, Dr. Antoniello. So she did not return to Jacoby for treatment or monitoring of her stroke. And the cases that we cite in our brief, Nykerchuk and Young and Allende, first of all, the further treatment must be explicitly anticipated by both the physician and patient. There's nothing in the record here to indicate that this plaintiff intended to return to Jacoby for treatment of her stroke. And in fact, the evidence is to the contrary. In Gordon versus Magan, the Court of Appeals found that no further examinations or follow-up consultations were proposed or contemplated. And here, in fact, the plaintiff did not contact or return to Jacoby. The hospital records show that she was advised that if her headache worsened, she should return to Jacoby, and she did not do that. In fact, she went to a different hospital. And basically, failure to diagnose is not a course of treatment. The law also requires, the inquiry ends there. This is not a course of treatment, but even if it were, the treatment has to be continuous, and the course of treatment must concern the same condition or complaint underlying the malpractice claim. So in Plaintiff's Bill of Particulars, he cites allegations to the effect that the Jacoby failed to diagnose the stroke, failed to order appropriate diagnostic studies, failed to consult with a neurologist or a neurosurgeon, failed to place a stent, things that are related to the failure to diagnose. There's nothing in the Bills of Particulars that relate to the later rehabilitation therapy that she obtained at Jacoby. This is a clear case of There is no course of treatment because the failure to establish a course of treatment is not a course of treatment. And the Court of Appeals in Nitrochek very clearly said that. The Court of Appeals cases that the plaintiff cites, none of them attempt to predicate continuous treatment upon an alleged failure to timely diagnose the condition. The patients in those cases remain under the treatment of the same or a related provider, and they did not seek and obtain medical treatment for the original condition elsewhere, which is exactly what we have here. So in McDermott versus Torrey, for example, the ankle condition, that she went for treatment of a mole on her ankle, and then she continued to treat with the same doctor for the ankle condition. In Borgia, also the child's brain damage, he continued to be at the same hospital for treatment of the continuing treatment of the brain damage. Here we don't have anything like that. We have a plaintiff who went to a different facility for treatment and monitoring of her stroke. She continued to have treatment for that stroke even now, and there is no continuous treatment for purposes of finding this notice of claim timely. We respectfully request that the court affirm. Thank you, Your Honor.
Thank you so much. Mr. Kessler, you have 1 minute.
Your Honors, there is no such thing as a continuous diagnosis case. There is a continuous treatment rule, and the entire purpose of the continuous treatment rule is that a patient may return to treat with that same doctor. The court in McDermott said, quote, "This is not to say that a complete discharge by a physician forever bars a finding of continuous treatment, included with."
Counselor, isn't my colleague right that she didn't return for continued complaints of headaches, but she returned for post-stroke care and rehab? Isn't that a valid distinction, and that's why the doctrine doesn't apply here?
I completely disagree with that concept, Your Honor. Under McDermott, under Borgia, under all the cases which I have cited, the entire purpose of the continuous treatment rule is for the patient to be able to return to the wrongdoer to get corrective treatment. And the cases say corrective treatment over and over again.
What corrective treatment do you get? She was getting rehab, right?
Correct. And that's
corrective treatment. Is that corrective treatment?
Absolutely, Your Honor, because
Mr. Kessler, McDermott involved an issue of fact as to whether the continuous doctrine, the continuous treatment doctrine applied. What's the issue of fact here? Because McDermott is not applicable.
I believe, Your Honor, that McDermott is applicable here because this patient returned quickly for continuous treatment, Your Honor.
Okay, I think we have your argument. We're going around in circles at this point. I appreciate both of your arguments. Have a good day.
I respectfully ask you to look at Borgia, please, Your Honors. Thank you.
Bain versus 50 West Development, LLC. Mr. Isaac, you have 5 minutes.
Thank you, Your Honor. Brian Isaac, I represent the plaintiff, appellant, cross-respondent. Let me start with the 240 sub 1 issue first, if I can, and then I'll go to the 241-6 issue, and then I'll answer any questions that you have. Our position is that under your decisional law, where you have a weight or a poundage that is not de minimis, and I know I'm using a double negative, not de minimis, but that's what the cases say.
But is that what the cases say, or the cases look at the weight? In this case, hold on a second. In this case, the plywood, there seems to be some dispute as to what weight was 100 pounds or more, right?
Correct.
So you're saying 100 pounds is not de minimis, and that ends the analysis.
Yes, I'm suggesting that there are cases that we cited. We cited to the Tropia case. We cited to the Gutierrez case, where you're dealing with numbers that are anywhere from 10 pounds to 40 pounds to 95 pounds to 175 pounds. This certainly isn't a super heavy case. I understand they have the super heavy cases like the Arab.
Did the A-frame cart in this case fall on the plaintiff?
Yes.
It was just applied. The cart fell as well?
Yes. So what happened is the plaintiff is coming. The best way to look at this, Justice Singh, is just to look at 295 and 296 of the record. These are affirmed photos. Nobody denies that this is what it looks like. The plaintiff is coming out and he's walking backwards. And the front of the cart goes into the hole or the gap that you see on the lower kind of right side. You have a really good close-up of it at 296. And you have the defendant saying on page 369 of the record that this was defective because it's not a good wearing surface. I think he means working surface because of the gap. That's at 369. The cart goes in, it's loaded with this kind of construction, this timber, which is going to be the subfloor of the regular floor. And then not only does that fall, the cart falls and the unsecured device, the unsecured lumber falls on him as well.
Counselor, take a look at pages 178 and 179 and tell me if the plaintiff says that the A-frame cart fell on him. He seems to be saying that just the plywood fell on him.
I have it right here. So he says, just let me go 177
178. Go to 178, bottom of 178, and tell me what he says with respect to the cart.
All right, hold on. I can't take this one. Yeah, and then he says the A-frame flipped. Did it hit the ground? When the A-frame flipped, if it hit the ground, yes. Answer, yeah. Did it flip completely? Answer, yeah. This is on 178, Judge. Question 16. So when it came to a stop, the A-frame, how was it positioned? If you can describe that, when it came to a stop, when it fell over, it fell on top of me. That's what he's talking about. It fell on top of me.
But then on the next page, he says that the ply was on top of me.
Yes, he says it. He says it in the next sentence, but he also says the A-frame fell on top of you. The ply fell on top of me. Question. The ply or the A-frame? Answer, the A-frame, when it flipped, the A-frame stay on the side, but the ply going to be on top.
Doesn't that suggest that it didn't fall on him?
There's both, Judge. I don't think it makes sense.
Okay, why don't you address 241.6?
Excuse me?
Address 241.6.
Yes, so the 241.6 claim is predicated on 12 NYCRR 23-1.22 B1 and B3. And as the trial court held, the gap in this, platform or ramp wasn't, quote, and this is, I'm going from 3, there's some similarity of language, but it wasn't, quote, substantially supported, braced, or substantially constructed to prevent excessive deflection. I think my adversary's position is that the term deflection would only apply to the ramp itself. I don't believe it can be so narrowly construed, because here the testimony was very clear that because of that gap, there was a deflection of the cart, and there was also a deflection of the materials that were in the cart. And under the Sawzin case, which my adversary cites to distinguish section 240, that's Sawzin against NYU, 158 AD 3D 510. This court actually granted plaintiff summary judgment on the 241.6 claim. And we would obviously, we're moving for summary judgment on that as well.
Does Mr. McCormick acknowledge that there was a gap and that this ramp, had he seen it before, it should have been, we would have had it replaced?
Yes, the site there, Judge, is, just give me one sec. It's 369 of the record. And he says, and I'm quoting, the condition was defective. He would have removed and replaced it because it was not, quote, a good wearing surface. And I think wearing means working. And that's what the court said also in one of the footnotes. So we would argue that this is a perfect 240-1 claim, a perfect 241.6 claim. One more point, and then I'll stop talking. My adversary says in the brief that the plaintiff doesn't know what caused him to fall. And Justice Singh, the portions that you and I were reading on 177 to 178, I think disproved that. The question that he's relying on is page 185, paragraph 5. And the question is, did you see the wheel go into the space? Answer, did I see the wheel? Yes. No, I didn't see the wheel going in. He certainly didn't see it because he couldn't have seen it. He was walking backwards. That doesn't mean he didn't know that it was there. So I would say there's a functional distinction between not seeing something and going into it intentionally, but not knowing what caused your accident. I see my time is up. I'll stop talking.
Thank you. Thank you so much. Okay, Mr. Herslier, you have 5 minutes.
May it please the court. I'm Nicholas Herslier for the defendants. Your Honors, I would submit that there's 3 cases that support our position. This is not a labor law 240 case. Grigo, Miles, and Davis cases. Those are all factually on point. And
how is the surface of this ramp a suitable surface for workers to traverse with a A-frame that's loaded with construction material. That is the worst ramp I've seen in years sitting on these labor law cases.
Your Honor, I'm willing to concede that the photo shows a ramp that's not in good condition. However,
No, it's not just not in good condition.
That's the ramp,
The
right?
former concede that it's not in good condition and that should be replaced.
but are we talking about 240?
We're
Because
talking about 41.6, obviously, on this issue, 241.6.
okay, because that's a really important point, because plaintiffs can't really articulate what the gravity-related safety device is that's supposed
We have held before that items that fall off of an A-frame device can constitute a 240 sub 1 violation. I've
Your
been
Honor,
on those cases, counsel.
I know, and I know that Your Honor was on the panel on the Torre case, but we just respectfully submit that case is distinguishable for a couple of important reasons. Number one, it was 1,600 pounds, which is a really big difference. In this case, it could have been even
Counsel,
100
all
pounds.
that means is that the difference between the injury is you're crushed by the item that falls, or you're just injured by it. So,
Your Honor,
at the end of the day, the labor law is drafted in order to protect workers. How was this worker protected with a ramp that just was inviting an accident to happen?
Your Honor, the weight is not a damages issue only because of runner. Remember, where we get these cases is from runner, when the Court of Appeals said, look, if it's a really heavy object, and even if it's a small, amount of descent, then it's still going to be a 240 case because that's a really big force that's capable. And that's where, if it's a really, really heavy object, like in Torre, it was 1,600 pounds. That's when it becomes a 240 case. But you can have definitely cases where it's de minimis, such as Grigo, Davis, and Miles cases.
Well, is this de minimis 100 pounds? Let's assume it's just 100 pounds. In testimony most favorable to you. Is that de minimis, or is it something more?
Your Honor, it's at least a question of fact, and here's why. Because when you have a tipping incident like this, we're talking about pieces of particle board, not plywood, particle board, which are 4 feet by 8 feet. So they don't fall on top of him like on his head, like with all 100 pounds. We're talking about something that tips onto him, so it's really only part of that weight. We could be talking about 40 pounds here. We could be talking about 30 pounds.
40 pounds on an ankle can fracture that ankle.
But that's not a 240 incident. It's not a case where something is being hoisted.
It seems to me that you're conflating these issues.
It's not something I'm trying to address 240 because, to steer the discussion that way, that's how plaintiff started his presentation. But I mean, it's not being hoisted or secured. It's not something, it's being moved horizontally, other than a 4-inch ramp, that's a de minimis amount that the ramp was actually going down. But in a tip incident like this, it's not like a falling object or a falling worker, and it's not something that was being hoisted or secured. And
Did
that was
the
enough
boards fall off of the A-frame?
They tipped off.
Did they fall off of the A-frame? Unless they stayed on the A-frame, counsel, they fell. They did not stay on the A-frame.
According to what plaintiff was just saying, is that the cart tipped as well. And why that's important is because in Torre, this court said that was.
I don't see how that helps you.
It's important because in Torre, this court said, and I quote, plaintiff was hit by the cement boards and not by the tipping A-frame cart. Meaning, in other words, if it had been secured to the cart, the accident would have happened in the exact same way. So the absence of his gravity-related safety device did not proximately cause the accident, because even if you tied these things to the cart, then it still would have happened with the same exact incident, because then you have the cart.
Isn't it possible to have several proximate causes of an accident? His injury was caused by two things here, no?
But what was the gravity?
Ramp which caused the A-frame to tip over, and the plywood that fell off the A-frame and hit him.
Your Honor, neither one of those things is a gravity-related safety device.
Okay.
The ramp is a ramp is not a gravity. Something tipping like this.
You have 2 minutes on rebuttal.
Thank you, Judge.
Mr. Isaac, you have 2 minutes.
Yes, thank you, Justice Singh. I apologize. I knew there was a different reference and I couldn't find it. I found it now for you. It's 181, starting on line 23. Question. And the cart, was that on top of you as well? Answer. Well, the cart is on top of the plywood. On the top of the, so I think what happened is the plywood fell and then the cart was on top of the plywood. That's on 181 to 182. One other point. I believe Justice Manzanet and Justice Singh were asking Mr. Herzl some questions about questions of fact. I think I can disprove his thesis. He said to you that there is a question of fact as to weight. Let me suggest to you, you're all very experienced trial judges as well. How would you present that to a jury? It's impossible. A jury can't determine whether a weight is sufficient to trigger the statute. I think that's a question of law. So assuming a worst case scenario for me of 100 pounds, the fact remains that this fell. It fell in a hole. The hole wasn't supposed to be there. And my adversary's cases that he cites do stand for the proposition he cites them for, but there's one gigantic difference. In none of those cases was the object being moved. In the Grigo case, it was just the object that fell because the plaintiff touched it. In the Miles case, there's a specific finding in the last sentence of the decision which says that the reason 240 doesn't apply is because there was no vertical movement, and they use the term vertical. So let me suggest to you that given the admissions you see on this record, we are entitled to summary judgment on the label law 240 and on label law 241-6. If you have no further questions, thank you for listening to me.
Thank you, Mr. Herzler. You have two minutes as well.
Your Honors, I would submit that, as my adversary just said, you know, the issue, he tries to distinguish our cases by saying something was being moved. But just because something is being moved doesn't make it a 240 case. Something has to be being hoisted or secured in a vertical way. It's about falling objects and falling workers. Here we have something that was being moved horizontally. Yes, it was being moved down a 4-inch ramp, okay? 4 inches is de minimis. In our brief, we cite a number of cases which stand for the proposition that 4 inches of difference is a de minimis amount. But even if you accept that, plaintiff still has not explained what was the gravity-related safety device that was missing. Was it something that was holding the particle boards to the cart? In which case the accident would have happened with or without that device. Because
isn't that right, counsel? At least the testimony is that there was nothing securing the boards to the cart.
That is true, but because if something had, because his testimony is that the A-frame cart ended up on top of the boards, and at least partially, we're just saying that even if they had strapped the particle boards onto this cart, that the accident would have happened in the exact same way. And plaintiff's testimony, by the way, not for nothing. Plaintiff testified 199, 146, and 200 that there was nothing wrong with the cart. There was nothing wrong with the way the boards were loaded. The boards did not need to be secured to the cart, and there was no other equipment needed to accomplish this task.
But the problem, as I understand it, is the ramp, and which Mr. McCormick acknowledges in his EBT that it was not, he says, good wearing service, and acknowledges that there was a gap, and that it should have been replaced, right?
But there's, Your Honor, yes, but
Isn't
there's
that
no
sufficient?
case.
Isn't that, putting aside 241, isn't that sufficient to grant summary judgment on the 241-6 claim? What's the issue of fact on that? Based
on the 241-6 claim, my adversary kind of lumped it all together, but
no, I'm not. I'm separating it. Based on McCormick's testimony and the photographs, what's the issue of fact with respect to the condition of the ramp?
Well, B1 is geared toward motor vehicles or heavier vehicles. That's number one. And then for B3, the other code section, that one, the plaintiff testified at 185 that he didn't even know whether the wheel actually went in. So that's a question of fact as to whether the car tipped because of the condition of the ramp, because he says, quote, no, I didn't see the wheel going in. He doesn't necessarily know that. And that's at least a question of fact.
Well, how else would the plywood have tipped over if it didn't get stuck in the gap?
Because they're rocking it back and forth. I mean, if you look at the ramp, it's maybe a little bumpy. I mean, there could be a lot of reasons. I mean, they're trying to jiggle it onto the ramp off of the platform.
You can't have it both ways. You can't say that there's nothing wrong with the A-frame, and maybe they were jiggling it back and forth. They were moving the cart as directed. on a surface that was not appropriate. That's why it tipped over.
Your Honor, when we're talking about 241.6, it has to be within the strict four corners of the code. And for all the reasons set forth in detail in our brief, there was no violation of section B3.
Thank you so much.
Thank you.
People versus Preston Norales. Ms. Moran, you have 4 minutes.
Good afternoon, Your Honors. Delorny Moran on behalf of Preston Norales, defendant appellant. Mr. Norales requests his sentence be reduced to 5 years. The legislator acknowledges that there could be a defendant convicted of attempted murder that did not require more than the stated minimum of 5 years. Mr. Norales is that defendant. At the onset, Your Honor, I want to acknowledge that we know and we recognize that the maximum in this case was 25 years, but the prosecution only asked the plea judge, Judge Yearwood, for 7 years. I believe there was this unstated acknowledgement throughout this case that this offense was an isolated incident, evidenced by the fact that Mr. Norales was released on his own recognizance and there was no new arrest for 2 years while he was at liberty, despite the complainant attacking him and his girlfriend during the pendency of the case. Even after he pled guilty, Judge Yearwood allowed him additional time in the community to finish up his outstanding work prior to surrendering to the Department of Corrections. Mr. Norales proved for 2 years that he was not a threat to the public and could be trusted in community, and this is why he's asking for a 2-year reduction. Mitigating facts of the offense is further evidence that this was an isolated incident. Mr. Norales does acknowledge he did stab the complainant who he lived with, and for that he is serving prison time. But what occurred on early mornings of March 13th included alcohol and high tensions between former roommates and friends. Both Mr. Norales and complainant required medical attention. What we do know of that night is that the complainant—
Counsel, the problem you have here is that, and admittedly, Mr. Norales was attacked first, injured first, but instead of going to the hospital and getting medical care and making sure that there was no further confrontation, he went home and waited for his roommate. And then repeatedly stabbed him again and again and again. We are lucky he didn't kill him.
Your Honor.
And why should we disturb such a heavily negotiated plea? Clearly, I mean, based on the record I reviewed, the defense fought hard for Mr. Norales to try to reduce his exposure as best as you could. And I think the office did a good job. Why should we undercut the deal that was struck with Judge Yearwood, who had all of these facts in front of him?
Your Honor, I do understand that the defense below did put on made great advocacy for this case, but this court does have discretion to reduce a sentence if it deems necessary. Additionally, the appeal waiver in this case, I do want to just touch that, is invalid. So there is no appeal waiver actually precluding. I want to state that it's invalid because the judge in this case did tell the defendant he would not be able to take this case to a higher court seeking to raise any issues or to change the agreement in any way. This statement, Your Honor, does convey an absolute bar that an appeal waiver—
I understand, but he did sign a written waiver in the presence of the court and was totally counseled on the issue and asked whether he had any questions with regard to the written waiver during the plea. Was he not? Yes. I don't disagree with you that the allocution by the judge on this issue left much to be desired. But that being said, isn't he covered by the written waiver and the progeny of cases we've gotten from the Court of Appeals on this issue?
No, Your Honor, he's not covered by that because in the most recent case, People v. Bazzano, which is December 15th of last year, the court is really emphasizing the statements that convey an absolute bar. Yes, Your Honor, I do want to acknowledge there was a defense attorney and the written waiver is signed by the defendant. However, the statement the statement from the court and the written waiver are contradicting one another. So therefore, a defendant is left to decide who is telling the truth. Is it no issue survived this appeal waiver, or is it the written waiver? When two statements contradict one another, we can understand why full deference is given to the judge whose statement in a courtroom is the most binding. So therefore, when the statement from the judge and the statement from the written waiver contradict one another, because we don't really, that's the two documents we explicitly know what was said, then, Your Honor, it makes the appeal waiver invalid. It's not like the judge left statements vague and therefore you can fill in the blanks with the appeal waiver. The statements.
I got it. Thank you so much. You're out of time. Mr. Commandoria, you have 4 minutes as well.
Good afternoon, and may it please the court, John Commandoria.
Why don't you start with that appeal waiver, which was indeed, the court's colloquy was problematic.
Yes, Your Honor. With regards to the appeal waiver, as Your Honor pointed out, he did sign a detailed written waiver. The court specifically inquired into him as to whether he went over that with his attorney, whether he reviewed that with his attorney, and whether he understood that. Only after the defendant swore that he had no further questions did the court give that colloquy. And while that colloquy is left to be desired, and I agree, and I will leave it with what the court commented before, it is almost identical to the colloquy in People v. Nicholson, which the Court of Appeals upheld in New York 3rd 248. And if I may touch about Bisono, which was decided on December 15th, there, the Court of Appeals reaffirmed its holding in Thomas that everything had to be looked at collectively. You can't just look at the colloquy in isolation of everything else and ignore everything else, just like you can't look at the valid appeal waiver and ignore everything else. And if you look at the fact that the written waiver was so detailed and it said that it was separate and distinct, it said that he was waiving his right to challenge the excessiveness of his sentence and that he retained the other constitutional rights. If you put that in conjunction with that counsel had went over that with him, that he swore counsel went over that with him, and that he told the court, I have no questions, that coupled with the colloquy, while it did leave to be desired, was enough to prove that he validly waived his right to appeal, foreclosing his ability to bring this claim. And if your honors have no questions with regards to that, just briefly with regards to the excessive sentence, Your Honor, Justice Manson-Daniels pretty much hit every single point I was going to make. But I would just like to point out as well that while defendant relies and he was injured first, he tries to justify and he continues to justify. And not once in the record has it been shown that he expressed any type of remorse or any type of apology for what he did. He stabbed his roommate 8 times, and the roommate has suffered permanent nerve damage. And if there's no questions, Your Honors, we ask that this court affirm the sentence.
Thank you so much.
Thank you, Your Honor.
Matkins versus 22 Little West. Mr. Persman, you have 7 minutes.
Good afternoon, Your Honors. May it please the court, my name is David Persman. I represent the plaintiff appellant. This is a case, as you well know from the record, involving an object that fell, a brick that fell from 6 stories above the plaintiff.
Was it 1 brick or more than 1 brick?
Our client testified it was more than 1 brick, but he was only struck by 1.
So bricks were raining down and he was hit by 1 brick from 6 stories. That would create some pretty horrendous injuries, wouldn't it?
Well, that's why the hospital records show that he had spine fractures and a 10 centimeter by 12 centimeter, which is 4 inches by 5 inch hematoma on his back, which he showed his boss at the scene of the accident. There's no question that they were doing demolition of brickwork on the bulkhead directly above the elevator shaft. There's no question that they left spaces in the planks because they were doing that in order to facilitate moving material up and down. There's no question that Mr. Vasquez went up to him and he immediately said, right after the accident, I got hit by a brick. There's no question that Mr. Hand went to the scene immediately after the accident.
Did Mr. Hand testify that he saw bricks at the scene after he went down? Didn't he say that he didn't notice any bricks on the ground?
His testimony given 3 years after the accident was that he didn't see bricks on the ground.
So
You're right.
how do we evaluate that versus what the plaintiff says?
Well, we've offered various theories in our brief. One of them is that it's a feigned issue of fact, because you would think that since this man was his employer and even made mention to him of the fact that, if you sue me, my insurance rates are going to go up. And he told him he knew he was injured because he was telling him to go to the hospital. Multiple times he tried to persuade him to go to the hospital. That when he wrote out his C2 report, which was his sole documentation in this accident that said plaintiff said he was hit by a brick, that he would have written down, I didn't see a brick. Instead, he comes into court 3 years later, having had nothing to do with this lawsuit for the 3 years, and on the record admits that he doesn't remember what happened yesterday, let alone what happened 3 years ago, and all of a sudden he has a magical memory that there were no bricks there.
But aren't you asking us to assess weight?
To credibility? Doesn't that go to credibility? Because you have Han saying one thing, plaintiff saying one thing. We know what Han wrote in the form saying claimant says, and your arguments now, doesn't that go to credibility, and the jury is to decide?
Well, not if the court deems it incredible as a matter of law for him to come up with that 3 years later when he didn't document it. He has nothing to refresh his recollection. There's nothing for him to refer to, and the man admits, I don't remember what happened yesterday, let alone what happened 3 years ago. I think it's feigned. I think that's the simple answer to it. Other than that, obviously, in any circumstance, a defendant can walk in to a deposition years later and say something that will create an issue of fact, but it has to be bona fide.
Can you address the issue of defendant's claim that your client is the sole proximate cause for his injuries?
Well, the only thing that I could see that would make him the sole proximate cause is he didn't run away fast enough. What did this poor man do?
Well, was your client working inside the elevator shaft? Where was he working inside the elevator shaft?
That's where he was cutting material, and there are many cases that have said that you cannot defend a 240 case, particularly by stating that the person was in a place they shouldn't have been, and instruction is not the equivalent of providing a safety device.
Well, was he told by his foreman to cut the decking in the elevator shaft?
There is no testimony about where he was told to cut the decking. He wasn't forbidden. There was no instruction prohibiting him from being in the elevator shaft. That's just where he was doing it.
Okay.
So I think I agree with Judge Kennedy that it puts a hitch in our rope. Absolutely, I understand that. But all the evidence, absent that magical memory that comes up 3 years later, proves that this man clearly was injured. He was struck by something. He had a 4-inch by 5-inch hematoma on his back, 2 lumbar spine fractures. It's observed in the hospital record. He showed it to his boss. His boss knows he's in pain. He told his boss immediately when the accident happened, and Mr. Vasquez, that he was struck by a brick, and that's what they documented. And then all of a sudden, 3 years later, they want to create a magical question of fact. I hope I've answered your question, Judge Manzanette Daniels.
Yes. Is there an issue, do you agree that there's an issue as to which of the parties was responsible for the falling bricks? That on the record as we have it, it's not possible at this point to ascertain which of the parties and which work specifically, whether it was the installation of the beams within the shaft in those notches, or the debris from the destruction of the staircase, or debris from the destruction of the bulkhead.
It
seems like there's a lot of different statements in the record about what was going on at the time.
And apparently all those things were going on, but the bulkhead where brick was being demolished, and it's in the records. It's in the record at page 9. I don't want to give them, not Brian Isaac. I don't want to. I'm trying to do this from digital
Memory.
records, and I got to tell you, if there's one thing that makes you crazy, it's trying to do this all from a digital record when you're 66 years old.
That's okay. We're basically the same.
It's in the log on page 647 is the log for the work done on November the 19th. And in that log, they say northeast they're called. We're doing demolition of the bulkhead. And the bulkhead, as you all know, is the protruding brick structure that houses the machinery of the elevator.
But other witnesses put northeast at a different location, right?
Yes.
So then why wouldn't, as my colleague is suggesting, why wouldn't that be an issue of fact?
Because a brick fell and hit him in the back.
But, well, one, there's a question as to whether it was intentionally thrown, right? And the other is where, how did the brick get down the elevator shaft?
If the defendants wanted to defend this case on what I consider to be a troublesome body of law, that when people are throwing things down, it's not 240, but when they're dropped, it is 240. Aside from whatever my opinions of those kinds of decisions, I don't understand them, but the brick did fall. Whoever was doing work on that bulkhead, which my client can't tell you because he's 6 stories below at the time, and it's unfair to put that burden on him, and that's why we have Labor Law 240. The object falls. It was obviously being worked on. There's no question that the records show demolition being done, continued demolition from the 17th, not on the 18th. Because I believe it was a Sunday, but yes, on the 19th, they're doing demolition of the bulkhead, which is directly above him, and things as a general rule, when they fall down.
Thank you. Okay, we will hear from 22 Little West, Miss Finocchio. You have 4 minutes.
Good afternoon, Your Honors. May it please the court. I represent the defendants, respondents, appellants. First of all, I think the court has clearly understood the factual issues that we raise in our brief. The problem that we have here is there really are conflicting versions of what had occurred. Mr. Hand, the plaintiff's employer, when he saw the plaintiff immediately after the accident, he didn't even see openings in the shaftway ceiling. So that would negate the plaintiff's contention that the brick actually fell through an opening.
Well, there's no question that something hit this man's back.
That's
and the
for
size
sure.
the size of his hematoma coincidentally seems to coincide with the size of a brick.
Your Honor, I wouldn't disagree with the fact that he was hit obviously by something, but the question is where and how. Mr. Vasquez of Northeast, who was doing the demolition at that time on the bulkhead, he didn't witness the accident and obviously doesn't know how it happened, but he also said the shaftway was closed. So it's not necessarily clear.
So are you saying that the testimony of the plaintiff that he maneuvered part of a siding through a hole that was created in that shaft is inaccurate?
Possibly, because the plaintiff's own workers' comp C3 employee claim form says demolition company was demolishing the walls. They didn't use a chute. They tossed the bricks down the stairway hole and the bricks hit him. So if someone intentionally threw something down the chute, it's not a 240 sub 1 case, as shown by one of the arguments and cases cited in our brief. The point simply being that we're not asking you to dismiss his claim. We're just saying that factual issues exist here. Now, the court also correctly pointed out that there's a lot.
But to you, the factual, I just want to be clear on what the factual issue is. So to you, the factual issue is whether he was even hit by a brick at all.
Well, that may be one of them. The factual issue is, how was he hit? What was he hit by? And if a brick did come from the elevator shaft, was it part of the permanent structure? The lower court correctly pointed out that that was one of the issues. It may not be deemed a falling object unless it was the kind of thing that needed to be secured or required securing.
Except that there's testimony in the record that several parties had been inside the shaft and had knocked out, chiseled out, whatever the proper construction term is, to create notches in order to put in beams to reinforce. So it seems to me that that argument, you lose that argument, the availability of that argument completely, the moment the inside of that shaft was being altered.
Well, Your Honor, first of all, it's unclear as to whether that was going on that day because of all the factual issues.
But it wouldn't matter whether it was going on in that day. If that work had been done in that shaft at any time prior to this accident, then it tells me that it is conceivable that there was a loose brick in the shaft that fell.
But
because of the bulkhead work going on above and the vibrations from that work.
Well, Your Honor, if that were the case, then it's still an issue of fact because Northeast was demolishing walls that day, and the plaintiff himself said they didn't use the chute. They were tossing bricks down the stairway hole, and that struck him. So what we have here is various versions about what was going on that day, how the plaintiff was injured.
Is the chute and the shaft the same thing?
No, Your Honor.
I didn't know so. Why is it being used interchangeably?
Well, okay, what the record shows is they were supposed to use a chute and they didn't. However, there's issues of fact about that as well. And that's the problem with this record. There's issues of fact.
Are you saying that it was possible that items that were thrown into the chute would fall into the shaft?
What I'm saying is we don't know what happened, and that's why
either the chute is connected to the shaft or it's not.
Your Honor, there was no chute. That's the problem. And if something was thrown, we don't know where exactly the plaintiff was. He says he was in the shaft, and he came out of the shaft and said he was struck. My point simply is that since we don't conclusively know what happened here, all of these things are issues of fact, and therefore Northeast, that leads me into my argument as an appellant against the other parties. Northeast should be brought back into the case because you can't conclusively rule them out as the source of the brick in this appeal. And then the next argument I will make is that Hanco, the plaintiff's employer, would, if plaintiff were entitled to summary judgment as a matter of law under section 240 sub 1, clearly his claim arises out of the performance of Hanco's work because he was doing work in the shaft as he claims. And therefore, we would be entitled to an order granting us summary judgment for contractual indemnification against Hanco. Okay. And obviously,
you're almost out of time, so I'm going to ask you to wrap it up.
I'll conclude by saying we also should get a conditional order against Northeast since, in the event they are
conditional. Counsel, is that correct? It's only conditional indemnification?
I would say Hanco should be a complete indemnification.
But isn't there some indication that you represent the GC, right?
That's correct, Your Honor.
Isn't there some indication that the GC was creating the notches or pockets in the wall? So,
Your Honor,
we're not clear, as you say yourself, how the brick came down. It could be the GC was negligent, no?
Well, Your Honor, because it's a very broad indemnity clause, that allows indemnity even if you're at fault. I guess it is conditional, but we would get indemnity to the extent we were not negligent.
Okay, so again.
But I'm not admitting negligence, but I'm saying if there were an issue of fact, obviously, then that would be the case.
Thank you. Mr. Walsh, you have 4 minutes.
Thank you. I'll be very brief, and may it please the court. I represent Hanco Welding. I just have to say, I jumped into this as appellate counsel, which is my job, backing up some of our labor law units. And I think I was more confused when I finished reading this record than I was when I started. And I don't say that to be glib. There are just so many facts going in so many different directions as to whether, yes, there's a chute, it wasn't being used. The GC is, Judge Singh, you point out, was involved in chipping away to create these pockets. My client may have been. They said they weren't there for a long time. They weren't there on the day of. There's a question of whether it's part of the structural, the shaft part of the structural part of this wall demolition project. There's a question, even with the plaintiff raised, that he may have cut a hole to use to hoist decking, because they were apparently decking the roof, putting decking on the roof where a lot of the contractors were. So maybe in the hoisting process, something fell. It's almost impossible to parse through the facts. And a jury will have a task at it.
Well, why is your adversary not correct that under the broad indemnification that the defendants, the GC, the owner and the GC are entitled at the very least to a conditional indemnification?
Well, as a fallback position, I can't say as a blanket rule that shouldn't be considered. But what I can say is that they haven't disproved their negligence in their
but that's the whole point of conditional indemnification. Well, that's an issue for trial.
Well, that's true. It will require two hurdles. They have to disprove the fact that they were negligent, and that they were free of it, and that we were negligent. That it falls completely on our shoulders. Again, Your Honors, it's certainly not a straight out contractual. Whether this court seeks to do what the lower court did not do and say it's conditional, there's no dispute about that. If the facts come down on us, it's us. If it comes down that they are not, meaning the GC, if they're not liable and it falls to us, well then yes, it's conditional. So that I have no issue with that in a broader context. I just think that there are so many facts that are left up in the air that this case has to go to a jury if it doesn't get resolved beforehand, before the judge's ruling could be overturned, or as you say and as you suggest, Justice Singh, perhaps it best be modified by a conditional order, but not an absolute one passed through at this junction. And that's the gist of my argument. I won't belabor unless there are questions for me.
Thank you so much.
Thank you, Your Honor.
Ms. Matera, you have 4 minutes.
Thank you. May it please the court. I represent Northeast Service Interiors. There are 3 witnesses who were deposed in this action who were present on the date of the accident. Plaintiff, of course, his employer, his supervisor, and Milton Vasquez, who was the foreman for the demolition workers. None of those witnesses have provided testimony that would suggest that this had anything to do with Northeast's work.
Well, what about the work logs that say that the bulkhead was being demolished? I mean, should we just ignore that testimony? Or
the one witness who was up on the roof just when he got the call that from plaintiff downstairs that he had an accident said Northeast workers were not on the roof, not at that time. Whether they were there in the morning, whether they were there later.
You're suggesting the logs are wrong, essentially, right?
Well, the logs don't say that Northeast was demolishing the staircase on the opposite side of the building, which is exactly what plaintiff said they were doing, which is what Milton Vasquez said they were doing, who was the Northeast foreman. So it's interesting because K&K did not produce the witness who actually prepared the logs. So even if they were doing work on the bulkhead, the only witness that we have who was up there on the roof where the Hanco workers were ready to take the decking that plaintiff was apparently cutting, that man who had every incentive to blame it on Northeast and that company said there were no Northeast workers. There were K&K laborers up on the roof, not Northeast workers. So what witness is there who will present evidence to a jury that Northeast was up there at that time? And then you have to assume that they would take bricks, and while the Hanco workers are pulling up whatever the steel decking, they would just throw a brick down there. No indication that this had ever occurred before this incident. And then again, we have with plaintiff that credibility issue. And it is a credibility issue for a jury that Francis Hand said. He goes immediately, walks down the stairs, the only stairs you could use to get right down there, and said there was no brick. And he asked him, where was the brick? And he saw nothing. And in terms
So
of,
I ask you the same thing I asked the other attorney. How is it that he coincidentally has a hematoma the size of a brick on his back?
I don't know that the hematoma is the size of a brick. He could have.
4 by 5 is the size of a brick minus an inch. Your average brick is 4 by 6, counsel.
Well, he could have, I don't know what happened to him, but I don't know if they were knocking out bricks in the shaft. We have no evidence of that, to reinforce the steel, because that's what the Hanco workers were doing, reinforcing the steel in the building. Northeast had nothing to do with it. They were discrete projects in this building. They were on the opposite side demolishing a staircase. And the issue of whether there was a shoot at that particular day, that's a red herring, because as the judge below recognized, they're demolishing bricks into a stairwell. He is in an elevator shaft on the other side of the building. What connection is there between
Thank you so much,
demolition?
ma'am. You're out of time.
Thank you.
I think we've got your argument, though.
Okay, appreciate it.
Mr. Perisman, you have 2 minutes on rebuttal.
Thank you, Your Honor. I think Your Honor is pointing to probably what is the single most decisive piece of proof. It's almost as if the defendants are saying to us, don't listen to what you see, listen to what I tell you. 3 years after the accident, when I didn't document it on the date of the accident. And considering how the courts are supposed to interpret Labor Law 240 to provide protection to workers, it seems patently unfair and unjust for a worker who is clearly struck by a large object in his back and has a mark on his back the size of a brick, who says he's struck by a brick right after the accident, who says to somebody else that he's struck by an accident, who lifts up his shirt and shows Mr. Hand what's wrong with him. And Mr. Hand says, you got to go to the hospital. You better go to the hospital. Instead, he drove him home, and he went to the hospital later on because he was in pain. And he's got 2 lumbar vertebral fractures. To turn around and say to that man, you got to solve the who done it and what done it, when what and who done it was 6 stories above him, and all he knows is he gets hit and he leaves the scene. It's not like he can stop and have an investigator go run up there and figure out exactly what happens. That's what 240 was created for, and I suggest that this court needs to reverse the lower court and grant the plaintiff summary judgment because of that.
Thank you so much. Jacoby versus Syracuse University. Mr. Confusion.
Confusion, Your Honor.
Confusion. You have 4 minutes. You may proceed.
Thank you, Judge. We're asking the court to reverse the Supreme Court's order that dismissed some of the counts of the plaintiff's complaint. Mostly, we'd like to focus on count 6 and breach of contract. 7 is promissory estoppel. 10 is defamation. And 8 is unpaid wages. The crux of my argument is that the Supreme Court dismissed the plaintiff's entire complaint on the grounds of res judicata, on the grounds of this Division of Human Rights determination, which is in the record at 145. Now, the Division of Human Rights said, well, I don't find probable cause, the administrative judge said, to find that there was a race discrimination. And it is what it is. As I've said in the brief, that does preclude his court complaint for state law race discrimination. It arguably precludes him from asserting any kind of a federal claim, and I'll get into that later. But that finding does not preclude him from asserting those 4 counts I identified. The breach of contract, if you look at his complaint, which is in the record.
But Counselor, isn't plaintiff, based on that unappealed decision by the Division of Human Rights, isn't he clearly stopped from arguing that the defendant acted improperly with respect to the breach of contract claim?
No, I don't think he's precluded from arguing the defendant acted improperly. He's only precluded from saying that you acted on the basis of my race. But if you look, for example, on page 12 to 14 of the record, in the plaintiff's complaint, he details the basis for his breach of contract and his related promissory estoppel claim. And they're really based on his allegation that Syracuse did not follow its own policies in terms of looking into the sexual harassment that was alleged against him and the manner in which it proceeded. And again, because this is a motion to dismiss standard, if you're just looking at the face of those claims in the complaint, they're not barred race judicata wise from the Division of Human Rights allegation. In other words, there's more to his complaint than just I was discriminated against racially or retaliated for my complaints of those race discriminations. And that's why I think the counts in the complaint I've identified should survive. Does that answer your Honor's question?
How do we deal with the unpled federal claims, the Title VIII?
The count two. Yeah, honestly, I think that's a much tougher argument for me to make because, I agree that he did not cite in his complaint any federal law, and he didn't plead a federal claim on the basis of the complaint. My argument is that if we're going to remand it and reinstate, at least from the pleadings forward, these other counts of his complaint, and in light of the federal law that seems to say that an administrative decision that isn't reviewed by a court doesn't have preclusive effect on a federal claim, I think he should be permitted to.
But you're asking us to rule on a claim that's not even raised. Wouldn't it be appropriate for you to make that motion below? And then we have that argument as to whether or not there's collateral estoppel or the federal law that you cite applies.
You could do that. He could have an opportunity. If his case is reinstated, he could move to, I guess, file an amended complaint where he could clearly state a federal claim. Unless the court has anything further.
Could you address defamation? Could you address the defamation claim, please, sir?
Yeah, on the defamation claim, again, it's really kind of the same argument. The Division of Human Rights only said, well, I don't find race discrimination. And if you look at the allegations in his complaint on defamation, and I argued this in a brief, he's talking about that he basically says that Syracuse and those few people he identified that worked above him went out and said that he sexually harassed, and that's why he needed to undergo the real rehabilitative training under their policy. And he said that's the basis of the defamation. And again, I think if you look just at the face of the complaint as a pleading, that's not race judicata barred based on the DHS finding that there was no race discrimination. It's a separate allegation.
There's also a statement that he acted inappropriately and unprofessionally, correct? That's part of the defamation?
Correct.
Is that can Syracuse at this juncture on a motion to dismiss argue that it's privileged? I mean, is that something that we should find, or is that something that should proceed through discovery and it's more an issue for summary judgment?
The latter, and I agree. It's the latter, Judge. I mean, the procedural posture of the case, I understand Syracuse's arguments, but they really, with regard to count 10, the defamation, as Your Honor suggests, and also really count 8, they make arguments that really go beyond the face dismissal that the Supreme Court gave it. So I think that those are things that should be decided later in the case.
Counsel, with respect to your cause of action for promissory estoppel, you don't allege an unambiguous promise or reasonable or foreseeable reliance and detriment, and that's required.
It is required. I think, though, Your Honor, if you look at his complaint, and again, I think under the law, it has to be construed, fairly liberally because he was pro se below. I do think he alleges enough in the 7th cause of action that's on 19 of the record. He says in paragraph 80, plaintiff reasonably and foreseeably relied to his detriment on these express and implied promises and representations I think there's enough there that you can look at his allegations and the 7th cause and say it states a complaint under New York law sufficient to survive a motion to dismiss, which again is the procedural posture of the case here.
Thank you.
Thank you for hearing the case, Your Honors.
Mr. Whitford Jr.?
Thank you. May it
1
please.
minute.
Thank you, Your Honor. May it please the court, Mark Whitford on behalf of the defendant, Syracuse University. Your Honors, we would submit that the trial court properly granted the university's motion to dismiss. As counsel has just indicated, all of these state discrimination claims are barred based on res judicata and collateral estoppel grounds based upon the findings from the Division of Human Rights. Additionally, all of the factual allegations that are part of the complaint in this action were alleged in the Division of Human Rights proceeding, that all those claims were there as well. But more importantly, Your Honor, and that was the reason why the trial court dismissed those claims as well. But as indicated in our brief, all of these claims, the university moved on several grounds, and that with each of these there was a failure to state a cause of action, and that these claims were barred by undisputed documentary evidence.
Can you address concern I have with respect to defamation, and that's with respect to the allegation that there was inappropriate and unprofessional. The argument is that that's privilege, correct?
That's correct, Your Honor.
Can that be decided on a motion to dismiss?
We submit that it can, and
is there case law that supports that, or aren't there cases that suggest that maybe that's an issue for summary judgment and we shouldn't be deciding it on a motion to dismiss?
Well, we have submitted cases, Your Honor, that have decided this issue. And the reason for that is because it's undisputed that those statements were made in the context of an employer responding to, frankly, threats that were made by an employee. It was in the context of an employee-employer relationship, and the employer was responding to an email in which the plaintiff had indicated, please read this email carefully, because if you don't, quote, what's coming next could hurt, end quote. And the university's response as an employer is to immediately respond to that, which they did, in indicating that that was an unprofessional.
I wish the university had taken the same degree of care with regard to the despicable comments that were made to this man. I thought I was reading a transcript coming out of Mississippi. How dare he think that it was okay for him to have a cup of coffee with a white woman on campus. It is outrageous, sir. Just simply outrageous. And we are bound by the decision of the division, but it doesn't mean we agree with it.
Understood, Your Honor, and I understood that the res judicata issue is a legal issue. And to that point, Your Honor, again, the university investigated, as they're obligated to do anytime there's a claim of harassment.
And what action was taken against his supervisor, who told him he had no business having lunch with a white woman? That what was wrong with him? What action was taken against him?
And Your Honor, I don't think there's any evidence in the record of what happened in that regard, and so I'm not.
If those statements were made, the university should have followed up, because you have a problem on your hands.
And again, Your Honor, in that investigation, which the university was obligated to follow through on, it determined that there was no evidence of any harassment on his part, and they notified him of that. And so,
but then they add insult to that win by saying, nonetheless, although we find that you did not sexually harass any of these women, you should have to take some corrective action, because notwithstanding you offended people, apparently, because you're not supposed to talk to white women.
Understood, Your Honor.
I mean, that's really the message that was sent to this African-American man.
Understood, but again, before this court and in this record, this appeal concerns his claims of discrimination, which the Division of Human Rights addressed, and the other causes of action, the breach of contract claim, Your Honor, which there is no contract alleged. He admits he's an at-will employee. The promissory estoppel
I haven't addressed that issue. I am dealing specifically with the discrimination that he dealt with. He dealt with a hostile work environment, okay? And again, the Division of Human Rights thought it wasn't sufficient. I'm not sure what would be in their mind. But
again,
this
Your Honor,
this is not a blameless situation for this man.
Understood, Your Honor. And our position with respect to the discrimination claims are that those were addressed in detail before the Division of Human Rights, and that is raised judicata and collateral estoppel with respect to his ongoing discriminatory claims, which the plaintiff admits is the case, Your Honor. And we understand that the court's position.
I understand. All right. You have 1 minute on rebuttal.
Unless the court has further questions of me, I would submit on my arguments and briefs, Your Honors.
Thank you. Have a good day.
Thank you for hearing the case.
Thank you.
Charlemagne versus Aquatic Recreational. Ms. Hassapidis, you have 5 minutes.
Thank you, Your Honor. Good afternoon. I'm Annette Hassapidis, representing the plaintiffs in this case. Respectfully, the lower court erred and should have denied all summary judgment motions and referred this case out for a jury trial. The court started with sua sponte addressing the issue of duty and breach when the defendants never raised the issue in their motions. It was uncontested. They proceeded on causation. There were no evidence or arguments.
Counselor, is that right? Didn't Aquatic actually address the issue of duty?
Actually, Your Honor, I know there's one sentence in their affirmation where they say under no.
I'm sorry to interrupt, but at argument, that's where the focus was. And didn't you acknowledge that you yourself had looked for case law on the issue of duty?
Well, let me go back. The one sentence where they say under no stretch of the imagination was there a duty or causation, that is the only reference there. There's no argument. There's no evidence. They provide no case law concerning duty in their motions for summary judgment. They did none of that. That is the that.
But you knew it was an issue, right? You knew duty is an issue.
Actually, the motions for summary judgment, the court will note, were simultaneously filed. Everyone filed at the same time. When plaintiff moved for summary judgment, plaintiff took no chances and proffered the sole expert affirmation concerning the duty of care of a lifeguard. The plaintiff did not know until the plaintiff simultaneously received the defense motions that they were conceding the issue. So we were taken aback when the court raised the issue of duty for the first time at argument. Does that answer the court's question?
Go on, please.
Okay, thank you, Your Honor. The court then ruled that a reasonably prudent lifeguard does not need to respond or render aid to someone unless they are exhibiting signs of drowning or distress and can communicate. Respectfully, the court erred. The court has the role of determining duty, but the court can look to expert opinion testimony as to the scope of the duty. The sole expert testimony that was never controverted by the defendants, and I would refer the court specifically to page 635 of the record, is that a lifeguard should not presume that someone is not in distress. Even if you think someone is joking, you treat them as if they are in distress.
Counsel, what signs were there that Mr. Shulman was in distress?
The signs, well, at 6:45, Mr. Bergen had been swimming laps for 2 hours. He suddenly stops, stands in the pool, looks in one direction, and does nothing. He's spoken to, he doesn't move. 5 minutes later, the same instruction is repeated to him, he doesn't move again. 7 o'clock comes, the instruction is made again, and he still doesn't move. Now, our expert has opined and explained that Red Cross certified lifeguards, which Aquatic, through Joel White, maintained they hired, although they never confirmed that Mr. Lopez was a Red Cross certified lifeguard, are trained that if someone does not respond to an instruction, it is the obligation of the lifeguard to make sure that they are heard and understood by the swimmer, and that all Mr. Lopez had to do was confirm that he could be heard and understood. And had he done that, he would have recognized immediately that this was a man in medical distress. I would also point out that the witnesses for the defendants acknowledged this duty. I'd refer the court to pages 240 and 241 of the record, where Mr. Joel White said that if a swimmer was not responding to an instruction, what should the lifeguard do? Repeat the instruction within a minute. And again, he's asked, what should he do then if the swimmer is still not responsive? According to Mr. White, he should take it up the, quote, chain of command by either calling Mr. White or calling 911.
Didn't Mr. Lopez indicate that he observed that the decedent had earbuds in his ear and presumably thought that that's why the decedent wasn't responding, because he couldn't hear him?
But the duty of the lifeguard is to make sure that he is heard and understood. That's not an excuse.
So, I mean, what was he supposed to do? Jump in the pool and stand in front of him?
Yes. And say, please pull out or pull out your buds and issue an instruction. We're not talking about one time, 2 times, 3 times. The 3rd time, what does Mr. Lopez do? He leaves. He leaves the pool area, which according to everyone, including Mr. White, is a breach of the duty to go get someone to get the building to come down and try to remove somebody.
So let's go down that line. And I was disturbed that Lopez leaves with this man in the water. Is there any evidence that the decedent died as a result of drowning?
The expert opinions did not indicate that he died as a result of drowning. The 4 expert opinions, the court did not address one of our expert opinions.
So there is no drowning in this case. He died of a heart attack or some other underlying medical condition, right?
The plaintiff's experts have opined that he died as a result of acute hypoglycemia, which triggered the cardiac event. The defense experts have, well, one of them, Dr. Thanning, has admitted.
So then how, just going with your expert opinion,
yes.
So how, even assuming that Lopez was negligent by leaving the pool, how is that approximate cause of the accident?
Well, by Lopez not confirming that not taking action and to determine whether or not there was a
But that goes back into the issue of duty, right?
Yes.
I'm trying to find a way where you're arguing that there was a breach by him leaving. I think you'd be in better position if, in fact, that there had been, for example, water in his stomach, right?
Well, Your Honor, our experts explained that he could have been saved at any point up until the time he was submerged in the water. Because he had this is a gentleman who was only diagnosed with diabetes in 2015. He had one prior hypoglycemic episode. His wife testified that she woke up in the middle of the night because she heard him groan. She immediately called 911 and he was resuscitated.
So Lopez, if I may, counsel, no one knew that the decedent had diabetes. He didn't disclose this information to the lifeguard or the employer or the management company.
Well, yes, I'm sorry, Your Honor.
No one knew.
Well, but they didn't need to know that. And that's the point that Mr. Gibbons, our expert, said.
Okay, you have 2 minutes on rebuttal.
Thank you.
Ms. Henderson, you have 4 minutes.
Good afternoon, Your Honor. May it please the court, Shannon Henderson of Kaufman, Borges, and Ryan on behalf of defendant respondent Aquatic Recreational. Your Honors, I would just like to first touch on the duty issue that the plaintiffs raised. At no point did Aquatic concede that it owed a duty for its lifeguard to assist a man who was not showing any signs of visible distress, who was standing upright in a pool. And contrary to plaintiff's allegations, he was responding, as Justice Calyx found. He was turning his head in the direction of whoever was speaking to him. Under these circumstances, the lifeguard here, Mr. Lopez, did not breach any duty to the decedent.
Could he have assumed a duty? Could Lopez have assumed a duty by his interactions with the decedent at that time? Is that a viable theory here?
I don't believe so, Your Honor. Based on the fact that, again, the decedent was showing no signs that he needed any sort of help. Even the hearsay testimony that plaintiff relies on of the building employees also indicates no one thought he needed any sort of help. They thought, imperfectly, obviously, that he was just refusing to get out of the pool. That's what it seems everyone involved thought. And even if there was any sort of breach of the duty, which we of course do not concede, there is absolutely no proximate causal connection between Mr. Lopez's actions and the decedent's death. The medical examiner concluded conclusively that the decedent did not drown. He died of what the medical examiner called overwhelming cardiovascular disease, including atherosclerotic disease, hypertensive heart disease, myocardial scarring indicating a past heart attack. All of these things combined led to a cardiac event that caused his death. There is absolutely no evidence that he could have been saved had he been pulled out of the pool sooner, despite the fact that he was not asking for help or exhibiting any sort of need for help. And if the court has no questions, we would rely on our brief that this case, this decision was correct by Justice Calyx below and should be affirmed.
Thank you. Ms. McDougall, you have 4 minutes.
Good afternoon. May it please the court. Stephanie McDougall of Dorff and Nelson for defendants respondents 300 East 85th Street and Rose Associates. My clients are the owner and property management company of the building. Quite simply, plaintiff claims that a porter and a doorman who came down to the pool should have recognized that the decedent was having an unknown medical event. The trial court correctly determined that there is no evidence in admissible form to establish that the decedent was visibly in distress or communicating a need for assistance, which would have warranted the building employees who were not CPR certified, who did not have medical training, to intervene.
Did your clients owe a duty to the decedent?
No, they did not.
Did you raise that?
I didn't. It was not raised within my papers, but the issue of duty was properly placed before the trial court. Plaintiff made a motion for summary judgment whereby they proffered an affidavit of a building superintendent who contended that my clients breached the duty owed to the decedent. Plaintiff opposed my motion with an affidavit of a building superintendent. The issue of duty was addressed at oral argument. It's well settled that a court may search the record, that the issue of duty is a question of law for the court. Therefore, the issue of duty was properly considered by and determined by Judge Calyx.
Does the residential building have rules with regard to the use of the pool? And was that in the record?
That was not within the record. The building contracted with Aquatic Recreational Management for Aquatic to operate the pool, to supply lifeguards, to open the pool, close the pool, manage it. It was kept under lock and key. It was within the basement of the building.
Okay, thank you.
Further, the court correctly determined that the causation opinion proffered by plaintiff's cardiology expert, Dr. Sidhu, was speculative. He replied entirely on the hearsay testimony of the decedent's wife and daughter regarding the statements related to them, allegedly by the building personnel. Therefore, it's our position that the trial court correctly granted our motion for summary judgment. And if the court does not have any further questions, I rest on the arguments contained in my brief.
Thank you. Ms. Hasapidas, you have 2 minutes on rebuttal.
Yes, thank you. With respect to the building's duty, I would point out at page 195 of the record is the building safety plan, which required that the staff do, quote, all that is possible to give immediate aid or attention to the injured person or persons, close quote. When the porter left the pool while Mr. Bergen was submerged in the water without doing anything, they breached that duty of care set forth in their safety plan.
But if
I agree that he should have been quickly pulled out of that pool, Ms. Hasapidas, but was that the proximate cause of his death?
Yes. Mr. Catanese is our forensic pathologist. In addition to Dr. Sidhu, he opined that the decedent could have been saved had he been pulled from the pool and resuscitated. He looked at Mr. Bergen's prior medical records, the records of the prior incident, and he said that he died as a result of untreated hypoglycemic. I asked the court to look at pages 1330 to 1331 of the record, again, because the lower court did not address Dr. Catanese's forensic opinion. He also opined that a glucose level of 47 is hypoglycemia and that his cardiac condition was mild and did not cause.
Counselor, did the landlord defendants, did they have a duty to give resuscitation, perform CPR, to have a defibrillator, for example, at the pool? Is that part of their duty?
No, we have only proceeded on the theory that they should have pulled him from the water and called 911.
Well, is there a case law that says that there's a duty to alert first responders, that the landlord has a duty to alert first responders?
The building safety plan says that they should do all they can to give immediate aid to injured persons. in the building. Furthermore, the court asked a question about the pool's rules and everything else. I would point out to the court that Aquatic was responsible for maintaining the logbook and all the records concerning the pool's rules, as well as the personnel records of Mr. Jordi Lopez. Aquatic produced not a sheet of paper. They claimed that the NYPD took possession of all of their files as part of a homicide investigation and proved nothing. And this worked apparently to their benefit. With respect to the argument that Dr. Sidhu's opinion testimony was based solely on hearsay, we strongly refute that. First of all, under Hampsh, an expert is entitled to rely upon hearsay evidence as long as it's the type reasonably relied upon by other experts. The defendants never countered that opinion, never proffered expert opinion to say it was inappropriate to rely on these statements by the other witnesses. Furthermore, that was not the sole basis of the opinion. The basis of the opinion is that he was not responsive and he did not exhibit signs of pain before he submerged in the water, and that he could have been saved immediately, just as if he had been pulled from the water, just as he had been a year earlier. Finally, this is an unusual.
We're out of time. Sorry, we're out of time. We've gone way over the time allotted.
Thank you, Your Honor.
Thank you. National Health versus Liberty Mutual. Appellant Liberty Mutual, Mr. Cram, you have 5 minutes. Mr. Cram, we cannot hear you.
Sorry about that. This should be better.
Yes.
Good afternoon, Your Honors.
Good afternoon.
We contend that the motion court erred in failing to dismiss National Health's New York insurance law claims by misapplying the Court of Appeals decision in Guyton. Here, plaintiffs' appellees own and operate nursing home facilities. They allege that they engaged the PRISM defendants as insurance brokers to obtain workers' compensation insurance, and that in 2004, PRISM presented a captive reinsurance program for workers' comp, which consisted of 2 parts. First, Liberty Mutual would issue workers' comp insurance policies, and second, a company would be set up to reinsure or assume a portion of the liability under the workers' comp policies in exchange for a portion of the premium. PRISM allegedly promised that National Health would be the sole participants and owners of that reinsurance company, such that it would only be responsible for National Health's losses. The idea was that if National Health had a good loss experience, it would share in the underwriting profits. National Health purchased workers' compensation insurance from Liberty in the years of 2004 through 2008, and it alleges that it was required as a, quote, precondition of the policies to enter into the reinsurance agreements and to provide irrevocable letters of credit as collateral for the reinsurance company's obligations. This is critical because if the program violated New York insurance law, as National Health contends, and we reject, because the reinsurance agreements and the letters of credit somehow constitute premium beyond the approved rates, then all of the factual predicates for their claims occurred at the outset of the program. Liberty Mutual elected to stop writing National Health's insurance in 2008, and National Health began to purchase workers' comp from Arch with a similar reinsurance structure. That was 10 years before National Health filed this action, only now that it knows that the program was not profitable for them, with the benefit of hindsight. Guyton, decided by the Court of Appeals, recognized that a claim accrues when all of the facts necessary to assert a right of action have occurred. It involved a claim under Section 349 of New York General Business Law. The plaintiffs alleged that they were led to believe—
This is Judge Singh, Counselor. In terms of accrual, when was the last time your company got additional premiums from the letters of credit?
Well, we would contend that the last time that they got additional premiums were when they were provided at the outset of the program.
In 2016, let me put it this way. In 2016, did your client get additional premiums from the LOCs?
We would contend that they did not get additional premiums because the LOCs had been provided, but yes, the LOCs were drawn down.
So why wouldn't accrual be as of 2016 when you drew down on those LOCs?
Because that is a consequence of the original setting up of this program back in 2004 through 2008, when National Health contends that as a requirement for getting these policies, it had to enter into these reinsurance agreements and it had to provide the letters of credit to Liberty Mutual. And it alleges in its own complaint, in its own language, that that was a precondition in 2004 in entering into the policies. So at that point in time, under the statute, it had both, Liberty Mutual had both allegedly required and received additional premium.
But it hadn't received it. But isn't there an argument to be made that it wasn't received? It was received in 2016 when you drew down on them. Isn't that a fair argument?
No, because Liberty Mutual received value in 2004 and 2008 when it was assured that there was security for the reinsurance and that as claims came in the future, they would be paid as necessary pursuant to the reinsurance. There was value there. And obviously, that is part of National Health's issue here because the letters of credit that they provided were irrevocable. Once they post them, they can't get them back, and they are drawn upon as required pursuant to the reinsurance. So they have given up that right. They've given up that asset. They've given up something of value in 2004 and 2008. That's totally different from what happened in Guyton, because the plaintiffs there were led to believe that they would not have to pay life insurance premiums beyond a certain date when dividends would have been sufficient to cover the premiums. The Court of Appeals found that a claim accrued at the point that it later turned out that the dividends were not sufficient to cover the premium. And that's when there was an injury that was required by Section 349 that occurred. Here, unlike in Guyton, National Health says that it was required to pay additional premium in order to get the policies in the first place. And so that happened at the beginning of the program, and we don't have to wait to see what happened if they're going to be required to do something in addition.
Thank you. Your time is up. Okay, Mr. Lewin, for
yes,
Arch Insurance, you have 5 minutes.
Yes, Your Honor. I would just add one more thing to what was said by Mr. Cram, which we certainly agree applies to Arch. The program or the structure of this turned over in 2008 to Arch. There was an initial pleading in federal court, I don't know if the court has focused on, that the plaintiffs brought, bringing state law claims and federal claims, which was dismissed voluntarily once the defendants filed a motion to dismiss in the federal court. In that pleading, as to Arch, they claimed, in answer to you, Your Honor, Justice Singh, they claimed that we had already provided additional premium on the posting of the letters of credit in 2008. There had been no drawdown by Arch as of the time of that federal lawsuit. So obviously, they believed that the claim was ripe and the claim occurred and it accrued prior to any drawdowns. So we agree with Mr. Cram's point that the charging, demanding, and receiving occurred at the outset of these programs. I will add a couple of other points that were not addressed quickly. Number two, to this point, there is no private right of action. The lower court found there was one. There's a comprehensive, robust regulatory scheme in Article 23 of the insurance law. There is even a provision 2316B that provides an express private right of action that doesn't apply to the claims here. So we believe that the court, relying on a one Southern District case, was incorrect in saying that there should be an implied right of action. The Court of Appeals has made it clear that the court should be reluctant in finding implied private rights of action, and we think it was erroneous to do so here. Quickly, there's a breach of contract claim for 3 years. Everything else is time barred, but the 3 years of the contract claim that we don't believe are time barred fails for another reason, which the court below didn't address, and that simply is the claim is there's a second contract knowingly entered into by the plaintiffs, which breached the first contract. That defies any logic how you could breach a contract's no modification clause by willingly, knowingly enter into another contract. So that really doesn't make any sense. And lastly, I want to say, because we're not going to have a chance, with respect to the cross appeal, there's an argument that was made by our adversary that in their papers that the Arch policies from 2012 through 14 should not be deemed time barred. We disagree with that. And the reason is very clearly that those policies all relate back. They're renewal policies. They relate back to the fraud, the one single fraud, which is alleged in 2008. 2008 was 10 years before this lawsuit was filed. It's clearly time barred. And lastly, I realize my time is running out. The court below did not reach the agency question. If this court were to overturn any aspect of the fraud issue and revive it, we maintain that PRISM was not our agent. By the pleading itself, it says that PRISM was the broker for the plaintiffs. New York law is clear. A broker is the agent of the insured, not the insurer. There is nothing that indicates that that PRISM had authority or apparent authority or any agency to act for Arch. And therefore, the one statement that's alleged by PRISM that they attribute to Arch in 2008 doesn't even constitute good law on saying that Arch could be held liable. The court never reached that issue because it didn't have to. But as this court is well aware, you can reach issues that were raised below that the lower court did not have to reach. I think my time is probably up, so I'm ending right there. Thank you, Judge Schmidt.
Thank you so much. Ms. Harrison, you have 5 minutes.
Your Honors, may it please the court. Catherine Harrison from Padawan and Weintraub, representing Prism Consultants, Asher Shore, Etty Shore, Woodbury, Comp Control, and Comp Control Insurance Company, SPC. I certainly agree with the general summaries of the case by my colleagues. Plaintiffs made a gamble here on reinsurance, and after it didn't work out for them 15 full years later, they now want to put the toothpaste back in the tube, not pay their obligations, and get out of the deal. I think basically the whole case can be boiled down to a statute of limitations issue, given that the key acts of alleged misrepresentations, as my colleagues have said, are in 2004 and 2008. With respect to the state statutes, first is New Jersey Consumer Fraud Act. There's only one New Jersey plaintiff in the case, and that plaintiff did not come into the Arch program until 2010. Therefore, there's no way that plaintiff could have been fooled or tricked or defrauded by comments that were made in 2004 or 2008. If, plaintiffs vaguely state in the complaint, everybody was reassured over and over without any specifics, at the very least, that claim would be accrued as of 2010.
Why not? Why not? And I know your answer, so maybe it's not a smart question, but why not? Why isn't accrual, again, for the same reasons when the LOCs were drawn down on?
Because plaintiffs allege that they had to pay additional premium and that they were required, as part of entering these reinsurance programs, that they were required to put up those letters of credit at the outset. And those letters of credit are evergreen, irrevocable letters of credit, which can be drawn down for any reason at any time without defense. So the value was given up by plaintiffs at the outset when those letters of credit were offered. And as the lower court correctly found, the drawdowns later were merely consequences of alleged misrepresentations that occurred in 2004 and 2008. So while the court below correctly found that the common law fraud claim should be dismissed, she did not do that with respect to the New Jersey fraud statute, again, because she got hung up on Gaydon. And I agree with the comments of Mr. Cram. Gaydon is distinguishable both because it's a different statute that's involved, and the facts are totally different because Gaydon involved an issue of future expectations, an issue which is not present in our case. Moving to Vermont, Vermont is slightly different. There's a Vermont Supreme Court case holding that the Consumer Fraud Act does not cover insurance. It's the Vermont Supreme Court. I don't think a New York court has any authority to ignore it. Plaintiffs suggest you can go with lower court decisions in Vermont. I don't think that's true. The Vermont Supreme Court has spoken. Finally, I just want to make clear that we have asked for dismissal of Comp Control Insurance Company, that is the Grand Cayman entity, on the basis that the court lacks personal jurisdiction over it. We offered an affidavit of somebody who could give the facts with respect to that entity's utter lack of contacts with New York. That's an affidavit which is at record 529.
Counsel, who controlled this entity? Was this entity controlled by the PRISM defendants?
I believe there is an allegation to that effect, but I think what the case law requires is that the control run in the other direction, that CCIC controlled the New York defendants, and there's not an allegation of that, and there are not facts that would show that. So I don't think that that is a sufficient New York contact for purposes of personal jurisdiction in this case. And I think I'm just about out of time. If there are questions, I'm happy to answer. Otherwise, we rely on our briefs.
Thank you so much. Mr. Glatt, we'll hear from you now.
Thank you so much, Your Honors. So a lot of issues were addressed. I'd like to start at the beginning. So the New York insurance law, the lower court held that this claim survives. The defendants, the Liberty defendants, claims that this claim is untimely and barred by the statute of limitations, and they cite the Gating case. The Gating case, which was cited by the order, stands for the simple proposition that a statute, in terms of for a statute of limitations for a statutory violation, follows the statutory language. Gating case did discuss a different statute, as defendants correctly pointed out, but Gating simply stands for the proposition that the court, as the order did here, the lower court did here, should look at the statutory language of the relevant statute which our claim is under. Here, under section 2314 and section 2339, the claim accrues, or a claim can accrue, because the statute has multiple violations, but the relevant one in which our claim survives is that it accrues when the defendant, the insurance company or its representative, receives a premium.
But Counselor, your adversaries argue that it's when the LOC is given, because it's irrevocable LOC. So why are they wrong with respect to that argument?
Thank you, Your Honor. Two responses to that. Number one is that the statute says multiple violations. It says when it's charged or demand or received a premium. So we submit, number one, that the receiving of a premium is only when the letter of credit is drawn down. And the second point on that is that defendant's only case in support of that is a Fourth Department case, when law from this department is clear that the beneficiary of a letter of credit is not considered the owner until it's of the funds until it's drawn down. Simply posting a letter of credit is not insufficient for a beneficiary to be considered the owner of the funds. So in terms of that, I think that answers Your Honor's question. To the next point, was raised about private right of action. That there's, I believe, Arch defendant claimed that there's no private right of action under New York insurance law section 2314 and 2339. As Arch alluded to, there was a Southern District of New York decision. In fact, the only case that has ever thoroughly analyzed this issue and has found that there is a private right of action under these sections. It is the only case, and Arch or any of the other defendants have not cited any other case which has ever analyzed this issue, and it did analyze and found that there was a private right of action, which makes sense because under Court of Appeals law, the way that an implied private right of action is analyzed under Court of Appeals law is whether, if it's the key factor is whether a private right of action would be consistent with the legislative scheme. And we submit that for 4 reasons here, these statutes are consistent with the legislative scheme. Number one, it uses the language shall, and shall suggests that, the defendant shall do something or shall not, suggests that there is a private right of action and that it's not left to the superintendent to enforce. Number two, and Judge Manzanet may recall, it's in the Lino decision, this held this second factor that there's no other enforcement mechanism anywhere in Article 23. The superintendent is not given any enforcement mechanism in anywhere else in Article 23, which again cuts to the point that there is an implied private action. Number three, there's no special expertise over here. Whether the rates deviated from the set rates or not is pretty basic. It doesn't require any technical knowledge, and therefore that also cuts to a private right of action. And fourth, for over 100 years, the statute has been in existence. It has been amended numerous times over the 100 years by the legislature, and they have never, ever expressed any intent to exclude such an implied private right of action, and they have in other in other statutes and obviously other parts of the New York insurance law. So all these reasons cut very much to our understanding that there is a private right of action under this section, as the Southern District, New York, did find as well. Moving on to the next point, Arch's counsel made a point that in 2000, that as a separate issue, we allege that all our fraud claims are timely against all defendants. But since Arch raised specifically 2012 to 2014 against Arch and Prism defendants, those years are obviously just against Arch because Liberty was already, the program for Liberties were done, but it's against Arch and Prism as well. Those claims are certainly timely. And in fact, defendants don't address this in their briefs at all, because the order said the reason why these claims are untimely are for the, and I quote, same reasons as the court found against the fraud claims against Liberty. But that is a little, we would submit that that's error. Every year of the program, there were new misrepresentations, both orally and through the brochures that were given specifically from Arch through to my clients. So therefore, the misrepresentations that were made against Liberty, even if the court found those untimely because they were from the years 2004, 2005, 2006, certainly the years of 2012 to 2014 to Arch are certainly within the 6-year statute of limitations, as this complaint was filed in 2018. So those are for sure timely. And just in terms of the point about, I believe the phrase that Ms. Harrison used was to put the toothpaste back in the tube, is that's not what our client is trying to do. The defendant stole the toothpaste holder. It stole the tube itself. And for 15 years, they concealed the fraud. And it was only when we discovered it in 2016 that we realized that for 15 years, we had been lied to and defrauded by all defendants. And so therefore, I think that analogy is in error as well. And I see we have 1 or 2 more minutes here. I'd just like to finish off with some of the minor claims that were raised is the consumer fraud for New Jersey. I believe Ms. Harrison mentioned that since that was only 2010, there could have been no new misrepresentations. But as I mentioned, each brochure made in misrepresentation each year. We call these brochures the TNC agreements in our briefs. In each TNC agreement, there was a new misrepresentation. So the fact that a New Jersey plaintiff joined in 2010 and received a brochure which had misrepresentations in 2010, therefore means that there certainly were misrepresentations made to it. And finally, to conclude with unless your honors have any questions, the Vermont statute, the Vermont claim rather, is the order held that it should be dismissed because of the Wilder decision, which was a 1981, I believe, decision from the Vermont Supreme Court. Subsequently to that decision, it was amended. The statute was completely amended, and it added in the words that even intangibles or other property or services of any kind are covered under this statute. A later Supreme Court decision of Vermont held that it wasn't addressing this issue only because the plaintiffs had shifting positions, but it indicated that that the amendment possibly did change Wilder decision. As well, that Supreme Court of Vermont decision held that when there's bad faith by an insurance company, then certainly it's covered under the Vermont statute, the VCFA section 2453. So therefore, we submit that here, when there was certainly bad faith there's fraud allegations, etc., by all defendants, we submit that it is covered under the Vermont statute as well.
Thank you so much.
Thank you, Your Honors.
Thank you. U.S. Bank versus Moran, Mr. Abramson.
Yes, may it please the court. On behalf of the plaintiff respondent, this is a residential mortgage foreclosure action in which as your honors know, the issue of RPAPL 1304 has been raised. However, both on procedural and substantive grounds, we believe that we submit that the trial court's order, Judge Blut's order, must be affirmed. Procedurally,
Well, is there a question about your client's failure to strictly comply with RPA PL 1304?
Well, if you want to jump to the substantive grounds,
well, I mean, at the end of the day, if that goes against you, it's over.
If at the end of the day, the court is going to review the sufficiency of the proof submitted by the plaintiff to determine compliance with the 90-day notice requirements under RPA PL 1304, then I believe we're on solid ground here. The evidence that was submitted in the form of an affidavit by Crystal McClelland, found in pages 593 to 614 of the record, combined with documentary evidence for which she laid a sufficient evidentiary foundation, I believe establishes strict compliance with the statute.
The notice was sent to the wrong address.
Well,
so how can that possibly comply strictly with the RPA PL?
The RPA PL 1304 says that requires that the lender send notice to the subject property, right, the mortgage premises, as well as the last known address of the borrower. So we see that.
Right, and the complaint here was sent to his address in Hudson, New York. So obviously.
Well, no, the complaint wasn't sent. First of all, the complaint was served in Hudson, New York. The plaintiff was unaware of that address.
Somebody had the address, right?
What was that?
Which means someone had the address.
Well, the process server, after doing its due diligence and its investigation, turned up that address, sure.
Wow, so that wasn't done the first time?
I'm sorry, I don't understand the question.
How was the Hudson address not discovered at this point?
So the borrower did not notify the bank of that address until months after. I believe it was after let's say it was February 14th. Let me see if I can pull up that date. February 13th of 2014. Well past the date that that the 90-day notice was sent to the last known address of the borrower. That address was not of record. The mortgage requires that the borrower update and provide another address to the bank if he wants to receive notice there.
But even the address of the mortgage property, wasn't there an error there? Wasn't it sent by first-class mail and certified mail to 240 Riverside?
Well, that was the last known address.
That's not a correct address?
That was the mailing address. It was also sent to the property address at 220 Riverside Boulevard.
Counsel, did that mailing to the property address, did that have an apartment number?
It did not have an apartment number.
And how large is that residential building that mailing was sent to?
That's a question of fact that I don't have the answer to, Your Honor.
I believe the record says 450 apartments.
So
I did not see that in the record. If that is I'm not aware of that.
So the chances that that notice didn't get where it was supposed to get are pretty high.
Well,
if you don't have an apartment number in a large building with more than 400 units.
Well, again, I don't know that building has 400 units.
220 Riverside Boulevard is a 50-story high-rise of 415 units. That's in the record at page 558 and 563.
Then I guess I need to ask the court to consider the procedural manner in which this issue is reaching the court. This was a defense that was abandoned by the defendant when he failed to raise it in opposition to the motion for summary judgment. He raised standing, but he didn't raise 1304, and we know it's not a jurisdictional defense.
Didn't he raise it as an affirmative defense in his answer?
Yes. He did raise it in the answer, and the plaintiff presented some proof of that. But he abandoned it when he failed to raise it in argument in opposition to the motion.
Doesn't our case law say that he can raise it even at the time of the foreclosure judgment?
Case law
and
also
therefore his objection now is timely.
Well, I don't think so. And respectfully, I think that case law also says that a defense can be abandoned. A non-jurisdictional defense can be abandoned and deemed waived if it's not raised in opposition to a motion for summary judgment. So I'll rest on
Counsel, just going back to the 240 Riverside Boulevard address,
yes.
It indicates Unit 12M, but the M line stops after the 7th floor, so there is no 12M
right.
at 240 Riverside Boulevard. So you have, an incomplete and an incorrect address.
I think if we're looking purely at whether or not the notices were sent to an address where the borrower was physically residing, I think the answer is no. The question, however, of whether the plaintiff complied with the law by sending a notice to the subject premises and to the last known address of the borrower that it had on record, the answer would have to be yes.
Okay, thank you so much.
Thank you, Your Honors.
Pastorino versus City of New York, Mr. Schweitzer.
Thank you, Your Honor. May it please the court. As the record shows, Mr. Pastorino was injured when he was trying to climb up onto a floating work platform in the form of a barge at a land-based construction site for the Broadway Bridge. As I mentioned in the brief, on photo, page A1496 of the record is a photo that shows the relationship of the actual boat that Mr. Pastorino was climbing from and the barge he was climbing to, and it's very similar to the way they were situated at the time of the accident. Now, Mr. Pastorino was not provided with a safe means to get from the boat to the barge. He had to climb a tire that was hanging from the side of the barge, which was extremely large, a payload.
Now, there's a lot of claims, Mr. Schweitzer, that there was this ladder available at the job site. I'm not exactly sure what they mean by that, but can you speak to us about this infamous ladder?
Early on in the job site, there was actually a ladder that came with that tugboat. Mr. Pastorino testified at some point it was damaged and lost and had never been replaced. There's in the record, I've listed numerous complaints by Mr. Pastorino and his coworkers because they were climbing this tire every day. Well, every day they worked on the other side of the river, and it was very difficult. The ladder was never replaced, and this argument that there is a ladder on a job site somewhere, or that Mr. Pastorino could have driven to Yonkers and got a ladder.
Counselor, this is Judge Singh.
Yes.
Didn't Griffin Sr. testify that there was a blue fiberglass extension ladder on the tug?
It might have been Griffin Sr. or it might have been Griffin Jr.
Well, both, but let's start with Sr.
Your Honor, they both testified that on the day of the accident, Griffin Sr. said he wasn't there. He had no idea whether or not there was a ladder. Griffin Jr. said he had no idea whether there was a ladder provided to Mr. Pastorino on December 5th, 2012, when he had to climb the tire.
So you're saying that there was no ladder, that these gentlemen testified that there was no ladder on the tug?
There was absolutely, there was 7 witnesses deposed in this case, and I lay it out in the brief. The city inspector.
Okay, so let me stop you. Go to page 1178, and that's I assume you deposed Griffin Sr. and you asked him about a ladder. Was that present on December 5th, 2012? The answer at line 12 of page 1178 is yes. The ladder was. He says on the job site. And then the question was that ladder used at all to gain access to and from the tug? And the answer is yes. Isn't that sufficient to raise an issue here?
Absolutely not.
To whether or not there was a. Go ahead.
First of all, Mr. Griffin said many things. He said he wasn't there that day. I took out a sheet and proved he was there that day. He said he was not on the tug and he has no idea, his words, whether or not there was a ladder available to Mr. Pastorino on the tug. he said there was a ladder on the job site. That doesn't mean there was a ladder available to Mr. Pastorino, placed and operated so he could use it to go the 6 foot difference. This is a big job site. There's a lot of workers. What Mr. Griffin's doing is trying to put the burden on Mr. Pastorino to supply the safety device, but that's not what the law says.
Mr. Schweitzer,
yes.
If indeed, let's say that we accept Mr. Griffin Sr.'s statement that there was a ladder on the job site as opposed to on the tugboat itself, does a ladder on the job site assist a worker who is on the tugboat
Absolutely
getting
not.
onto the barge?
Absolutely not. How do you get?
Would he have to get up on the barge in order to access the ladder?
Exactly, Your Honor. He would have to climb the tire and then go walk the entire job site to try to find this ladder that may exist or may not exist. But it does no good to the people on the tugboat if there's a ladder somewhere else on the job site.
But didn't Mr. Griffin testify that the ladder was tied to the side of the cabin and it was a blue fiberglass ladder? And then you ask him, was that present on December 5th, 2012? And the answer is yes.
No, the answer is no, Your Honor. Clearly no.
Sir, respectfully, look at the page, look at that page and look at the answer. I'm just reading what it says.
Well, first of all, Your Honor, which Mr. Griffin are we talking about?
I'm talking about, so far, it's Jay Griffin, which is senior, right?
Okay, Mr. Griffin Sr.
And that's on page 1178, and his answer appears on line 12.
Well, I'm not sure about that answer. First of all, if you read my reply, Mr. Griffin and his son's testimony should be thrown out in its entirety because they contradict each other. Mr. Griffin was a boss on the job site. Hired his son, and his son testified that his father was never there except for a couple of days a week, and he didn't know what his father's job title was. Mr. Griffin Sr. testified that his son never drove the boat. His son testified he drove the boat every day. I mean,
Mr. Schweitzer, why don't we deal with another issue? The claim that the workers had another means of getting to the job site where they would be working on that day with respect to the, what was it, some kind of
hatches?
A hatch?
Yes. That
is. Can you address that issue of the hatch?
That is a story that was concocted by defense counsel after the testimony of one witness, a supervisor for Commodore, who learned about what happened here and said they were not supposed to use the boat in that manner. And from that, now, the defense argument that the workers should have gone down the hatch, which is how they accessed the shanty, where they changed their clothes and got their tools, and they should have picked up their tools and climbed up the ladders, the vertical ladders, to climb up the side of the bridge abutment, crawl through a hatch with the tools, carry them across the bridge, then open up another hatch and crawl down the other side, carrying chainsaws and sledgehammers and bars. I mean, that argument is so ridiculous. The lower court didn't even mention it in the decision. As a matter of fact, the lower court said the workers on the Broadway Bridge project commonly used these tires to gain access when the pressure to the work barge, when no other devices to access the work barge were provided. It happened every day they worked on the side of that river.
Okay, you have 2 minutes on rebuttal. You have 3 minutes on rebuttal. We're out of time on your original argument. So I'm going to go now to Mr. Lawless for the city.
Good afternoon. May it please the court, Patrick Lawless for defendant respondent, New York City. With respect to the issue of the hatch, there was testimony in the record that the plaintiff was and the workers at the site were supposed to access both barges, the work barge that was on the Bronx side of the bridge and the shanty barge that was on the Manhattan side of the bridge by using.
Counsel, I have to tell you that Mr. Schweitzer's arguments, quite frankly, seem to carry real weight, in that it would be ridiculous to have workers traversing the side of a bridge with tools in tow up and down on each side. And there's no evidence in the record that that was ever ordered to be done by anyone, or that that was the practice at all on this job site.
There's testimony that from the supervisor that was supposed to be done, and also there's testimony in record that
is there testimony anywhere that was the practice of all of the workers at this site for this job? I saw nothing to that effect in the record. I saw this statement, this argument about this hatch, but I saw nothing in the record that any worker said they did that, ever.
There was testimony that that one of the supervisors witnessed the men on using the tugboat, and then told their supervisor not to have them do that anymore and to use the hatches. And on top of that, with respect to the practicality, there is testimony in this record and evidence in this record that tools could have been stored on the work barge, that there was a toolbox on the work barge that the tools could have been stored, but also there were pulleys which allowed tools, and it was common that tools and materials were lowered down by these pulleys on the Bronx side of the bridge via the hatch. So there was another method, and a proper method of ingress and egress for these workers to access the work barge other than the tugboat. And with respect to, I mean, it's not even relevant because there was a proper method of ingress and egress, but there was, not only did Mr. Griffin Sr. testify that there was a ladder at the site, but Griffin Jr. also.
Well, when you say at the site, what do you mean at the site?
No, I'm sorry.
On the boat? Do you mean at someplace in Brooklyn? I mean, what's the site?
Affixed to the tugboat. Both Griffin Jr. and Griffin Sr. said that there was a ladder that was always affixed to the tugboat. Griffin Sr. said it was affixed on the date of the accident. What the plaintiff's counsel is asking is to make credibility determinations, and anything that contradicts his version of events should be just thrown out. That's not proper in a summary judgment motion. In addition, I understand that the grounds for that the lower court dismissed the claim against the city, but as an alternative grounds for affirmance, even though the lower court found in opposite, that the party action is barred by the LHWCA, because unlike the cases cited by the plaintiff, this was completely on two vessels, particularly on a tugboat, which had no.
But let me ask you this: I read the Cameron case, and wasn't the work the same?
What's different about the Cameron case?
Well, no, just answer my question, not the question you want to answer. Wasn't the work the same?
The work was the same, but the circumstances are different, because the work happened while work was being performed on the barge itself, which was permanently affixed to the bridge, where in this case, the plaintiff was on a tugboat, and the barge at issue was frequently moved. It wasn't permanently affixed to any land-based.
But you know, you say, for example, that the work site can be assessed through the hatch. It sounds to me that it's completely local. It has nothing to do with navigable waters, correct?
Well, it has to do with navigable waters in the sense that the plaintiff was on a tugboat at the time, using a tugboat as a means of transportation to access the work barge.
Okay.
Unless the panel has any further questions, I'll rest on my brief.
Thank you. Mr. Crow for Commodore, you have 5 minutes.
Good afternoon, Judge. Just a quick point on this hatch. If you look at page 1791 of the record, it shows you what we're talking about. Listening to Mr. Schweitzer, you would believe that they had to cross the Verrazano Bridge lugging gigantic tools. As pointed out by my colleague, there's a toolbox. There's clearly ways to get down a very simple ladder, and this is what was directed by the supervisors on the job. And the reason being, as testimony from Commodore, we did not want people out on the water. They undertook this project, the city, Commodore, everybody, with the view that this was not to be used as a ferry. And that gets me to my point that what we're dealing with here is a federal workers' compensation statute, which makes the employer, my client, immune from suit unless there's very limited circumstance where they are known as a bareboat charter. And to become a bareboat charter under the federal case law, it requires exclusive control and navigation ability. What we have here is a lease for the use of this ferry called the Under Pressure, and it says you can take the plaintiff and Ocean, nobody discusses the language, but it's very simple. This is going to be unmanned. It's going to sit on the site, and if on those occasions when you need to move the barge from one side of the river to the other, you can use it. But let Ocean Marine know, and we'll take care of it. Or if you need to bring fuel, we'll take care of that as well. It's at 1276 for the record. So that's the operative language. In order to be liable, they have to have this type of control. And there's numerous cases from around the country that discuss this statute. And for instance, in the Sixth Circuit, in the Durham case, the court says we need to have restrictions. It's not a bareboat charter when it could not use the vessel for its own commercial use. If you take the plaintiff and Ocean Marine's argument to the extreme, they could have taken this ferry or the pushboat tug up to the Hudson River, or maybe take it to Jones Beach if they like it. That's the type of control they're suggesting we have. And obviously that's not the case. They were limited solely to this project and solely to that location. But beyond that, even assuming we're a bareboat charter, the claim relates to negligence, quote unquote, of the employer in failing to enforce the contractually mandated access through that hatch at page 1276. They can't refashion this, rejigger it and say, well, we're not talking about negligence in failing to come down the hatch. We want to just talk about the vessel. And as a result, we're going to make a longshore claim. That just doesn't make any sense. A few other items. I just wanted to mention that the city's cross claim for indemnification is barred under precedent from this court by the anti-subrogation law, and the cross claim by Ocean Marine is explicitly barred by the statute 33 U.S.C. 905. Notwithstanding that, Justice Gorin granted summary judgment to Ocean Marine on their cross claim for indemnification.
Thank you. Thank you. Mr. Vitanza, you have 5 minutes.
Sorry, good afternoon, Your Honors. So I'll address the bareboat charter issue. First and foremost, the language of the contract is clear that Commodore is getting the vessel without it being manned. It was unmanned. And if you look at the testimony of Ray Speckman, who's the executive project manager for Commodore, he said that it was a bareboat charter and the vessel came unmanned. He also says that if Ocean Marine had been hired to be the captain, or if anyone had been hired to be the captain of that tug for that project, there would have been a separate captaincy contract, and that person would have had to produce their captain's license to Commodore, and that person would have been paid separately, whether it was Ocean Marine, Joe Griffin, or anyone else, than they were for doing work at that project. So we sent discovery demands to Commodore. There's no contract, there's no captaincy contract with anybody, and there was no extra payments into Ocean Marine or anyone else for captaining that tugboat. It's very clear that Commodore said, hey, we're hiring Joe Griffin to be the general foreman for this project, so we might as well just take advantage of it and double dip on that and allow him or his son to move that tug as needed. It's very clear that everything that was done at that project by Joe Griffin Sr. or Joe Griffin Jr. or anyone else was as a Commodore employee, not as an Ocean Marine employee. Nobody testified to that. There's no evidence to that. All paychecks, all daily work logs say Commodore, Commodore, Commodore. Nothing says Ocean Marine. So the issue is to the bareboat charter, we think, is a moot point. As to whether or not the tug was delivered to Commodore in a seaworthy fashion, as Justice Singh has reiterated a few times, it's clear that there was a fiberglass ladder provided with the tug. Even Pastorino testified to that. There might be a question as to when it was destroyed, but at the time it was the tug was issued to Commodore, it had a ladder on it. Also, the Night Moves barge that was issued to Commodore through Ocean Marine, even though it was owned by someone else, also had a ladder attached to the side of it, which is on the inspection record report that was provided before the barge was used. So there was the ladder on the barge and there was the ladder on the tug. Also, this tugboat, it sits, the gunwale sits about a foot above water. To get on and off of this tugboat, you just have to step off of it to get onto the deck. I understand that they were using it improperly to climb the tires on the side of the barge, but that wasn't a proper means of ingress or egress. The fact that the Commodore employees and the Commodore foreman, including Mr. Pastorino, decided to do that doesn't mean that Ocean Marine didn't provide that tug with a proper means of ingress or egress. The tug in and of itself, by walking off the gunwale, provides proper ingress or egress. So in short, there was a ladder attached when it was chartered. It was clearly a bareboat charter. That's whatever Commodore's attorney wants to say, that's what Commodore testified to. And the last point about the indemnity, we understand that there's the issues with Longshoremen Worker Comp Act. This case is different for two reasons. First of all, there's a special owner, which is Commodore, who took on the bareboat charter. And secondly, the cases that Commodore cites, none of them deal with the case where the person that's required to indemnify brought in the owner. We're a third-party defendant. They brought us into this case seeking defense and indemnity when they had a duty. The only language in the contract is that they have to defend and indemnify us. So it's complete bad faith to bring us into this case when you took a bareboat charter from us, you took the vessel from us, and potentially destroyed the ladder on the boat, and then ask us to pay for our own defense costs. I don't see any case law or anything saying that we're not entitled to defense costs when they're a special owner and they bring us into the case and there's language and clear vicarious liability requiring them to indemnify us.
Thank you. Mr. Schweitzer, you have 3 minutes on rebuttal. Unmute.
Thank you, Your Honor. First of all, I agree with Mr. Vitanza that the under pressure, it was a bareboat charter as opposed to a time charter. A time charter is when you charter a boat to go out for the day. You show up, it comes with a captain who drives around and brings you back to the dock. You don't drive the boat. You don't touch, you don't go into any place on that boat where you don't belong. Commodore chartered a boat. Commodore provided a captain. Commodore made the decisions on how the boat was to be used. Mr. Pastorino made no decisions on how that boat was to be used. Yes, there was, Mr. Speckman said they shouldn't have been doing what they were doing with the boat, but the fact of the matter is they were. What's very important is, first of all, with regard to the photo A14 on page 1496 in the record, there's no ladder on the boat. Every time I showed a picture to Joe Griffin Jr. of the boat, there was no ladder on it. The boat that he said always had a ladder on it.
Is counsel right that there was a ladder on the barge, or is he wrong about that?
There was a ladder on a barge on a certain day. I don't know about there was no ladder provided on the date of the accident.
On the barge, not the tugboat, the barge. I just want to know if he's right about that statement.
There was no evidence that there was a ladder on the barge that day.
Okay.
Now, a lot of times when we write briefs, we summarize the testimony. This is very important. I cited the testimony. I didn't summarize it because Mr. Griffin, first of all, there were 7 people deposed. Mr. Pastorino, Mr. Culligan, Mr. Murray were there. They all said there was no ladder. Mr. Murray said, I don't remember, but I would have never been climbing a tire if there was a ladder. I remember complaining about climbing a tire, and I never remember a ladder being on the tug. Those are 3 witnesses said no ladder. The city inspector said, I wasn't there that day. I don't know. Mr. Speckman said, I wasn't there that day. I don't know. Joseph Griffin Sr. on page A1181 of the record. No, I'm sorry. A927. Question, you were not present on the under pressure when Mr. Pastorino had his accident, correct? Answer, correct. You have no knowledge whatsoever if that ladder was on the under pressure at the time Mr. Pastorino was injured. Isn't that correct? Answer, that's correct, yes. Because that knocks Mr. Griffin out. He has admitted he has no knowledge. His son, I asked him, this is page 8.
I'm gonna give you 30 seconds more.
1233 and 1234. Talked about the ladder. It was usually tied. That was his answer. Usually tied to the side of the under pressure, the tugboat. Question, it was kept on the boat? Answer, sometimes people took it off if they needed it. Question, now do you have a specific recollection of whether that ladder was on the tug under pressure on December 5th, 2012, when Mr. Pastorino reported he was injured? Answer, I don't remember. Question, you don't know if the ladder was on the tugboat at all? Answer, not that day. Therefore, there is no evidence there was a ladder on that boat at the time Mr. Pastorino was injured. He had no decision-making power on how the tug was to be used. Mr. Griffin admitted he climbed the tire himself. Son and father, they both admitted they used the tugboat to ferry the men across the water with the tools and the materials. Therefore, the lower court should be reversed. Summary judgment should be granted to plaintiff on his 240 and his 241-6 claim should be restored.
Thank you. Montefiore Medical versus Empire Health Choice, Ms. Chapman.
Thank you, Your Honor. Erin Chapman for defendant appellant Empire. May it please the court. Courts across the country have understood the Medicaid payment in full requirement to mean precisely what it says. That once a provider accepts Medicaid funds, it cannot seek to recover additional funds for the services it provided. Up against that clear language and without a single case supporting its contrary view, Montefiore is left to argue that this cannot be what the regulations mean because it means
this wasn't a Medicaid, but this wasn't for Medicaid services.
That's not correct, Your Honor. So the Medicaid regulations are triggered by the acceptance of Medicaid funds, and no one disputes that here Montefiore did that.
But Counselor, is it undisputed that the payments by affinity were made in error?
So the complaint doesn't detail specifically the facts.
So for the purposes of this motion, shouldn't we assume that the affinity payments were made in error?
So both of the briefs refer to them as a mistake. I think that's correct.
So if it was a mistake, why would the regulation take precedence over a contractual provision, actually a very detailed contract in terms of how these disputes are to be resolved? Why would the regulation would trump the contract?
So Empire is not arguing that the contract is trumped. It's arguing that its obligation under the contract never arose because of the Medicaid regulations. Go ahead.
I'm sorry. But we've established that there's an error. We've established that it's an error in the first instance, right? So under the circumstances where payments, at least for the purposes of this motion, were made in error, why wouldn't the commercial insurer under the contract be responsible, irrespective of what the regulation says?
So I don't think you can separate what the regulation says, Your Honor, and that's because this contract between two bodies in the medical system was made against the background of these Medicaid regulations, and they were contracted knowing full well that those regulations, which predated the agreement here, were part of the context of the contract they were entering into. And it's because of that, those regulations that are triggered on acceptance, that they're relevant here, because Montefiore did in fact accept Medicaid funds. And
Is that language contained in the contract, in the underlying contract between your client?
So we don't have the pages of the contract that refer to that specifically, and there hasn't been an allegation about that in the complaint, but we do know that in the model Medicaid contract.
But this is, again, you keep on referring to the Medicaid contract, but this is not that.
So Your Honor, it is because what a provider agrees to when it agrees to participate in the state Medicaid program is that whenever it bills the state for Medicaid services, as it did here in this case, that it's required to accept that payment as payment in full. And that requirement was a background requirement that the parties contracted around here. And it's a fundamental part of the bargain.
How would this not create an incentive for insurance companies like your client to make errors in order to bypass the higher rate of the contracts they sign with the hospitals?
Your Honor, on the contrary, the provider that's in the best, the party that's in the best position to avoid billing errors is the provider. They're the ones who have the opportunity.
So in other words, you're not seeking to exploit a mistake here. I mean, that's what it smacks me of, that you are attempting to exploit a mistake. And a mistake not made by you, made by Affinity, and your position as well. You know, Montefiore should have discovered that mistake. But the mistake, I don't see why you should get the benefit of the mistake.
So, Your Honor, the payment in full requirement makes it so that when there is a mistake, as there was here, that there are consequences for that. And one of the consequences is that a provider is not able to seek out additional funds. And you're correct that that means in some instances like here, that insurers pay the lower Medicaid rate. But that is a feature, not a bug of the Medicaid.
But that abrogates the hospital's contractual right to coordinate benefits, to be able to make claims when there are mistakes. I mean, we're just throwing all those provisions of the contract out under your analysis.
Your Honor, what we're saying is that those obligations did not arise because of these Medicaid regulations that the parties contracted around and that the parties were well aware of when they entered into that agreement. And that's for important public policy reasons. It places the burden of checking for third-party coverage on the party best suited to avoid an error, and that's the provider. It also prevents the Medicaid program from becoming a financing entity that gives interest-free loans to providers. It ensures that providers thoroughly check before they bill. And then that also makes it so that the providers are held to the fundamental bargain that they made when they entered into the Medicaid program.
Except the corollary is that you're not held to your bargain of paying higher rates as a commercial insurer.
So the court in Mallow, which is one of the federal district court cases, talks about how in instances like this, when mistakes are made, that someone is bound to get a benefit from it. What happened in this instance is that the regulations decide that the person who has to foot the bill is the provider who is in the best place in the first instance to prevent this error. And that's a key incentive that makes the Medicaid program work and keeps the program from having to pay out for claims that providers make when they haven't thoroughly checked for third-party insurance.
And I don't think I've ever heard anyone say that the Medicaid program works, so that's interesting. I will hear from Mr. Keene.
Good afternoon, Michael Keene from Garfunkel Wild from Montefiore Hospital. This is a simple contract case, and I want to address some of the clutter that Empire has sprinkled on it and make a few points. First of all, this is not a Medicaid case. There are no Medicaid beneficiaries involved here. The state Medicaid program is not involved. And there was a statement a moment ago that we billed the state Medicaid program and took money from them. That is wholly not true. Nor is there a responsible Medicaid MCO involved here. All that is left is a private hospital and a commercial insurer with a commercial provider agreement. The lower court recognized this, and its decision was sound. Second, this is not a federal case. Throughout Empire's papers, they cite federal laws and federal regulations. And when you look at those laws and regulations, you will see that they all start, quote, a state plan must, close quote, and then it goes into the requirements that any state that wants to submit an application to receive federal block grants for Medicaid must include in their state program. Those are all laws between the federal government and the state government. They have nothing to do with Empire. They have nothing to do with Montefiore. They have nothing to do with Affinity or how those three entities conduct their business. Third, throughout Empire's briefing, they say there are no cases, that Montefiore has cited no cases on the particular set of facts before the court right now. That's a red herring. Neither side cited a case to you with these set of facts because they're unique, with Empire trying to capitalize on, we call it a mistake, but a misbilling that occurs every single day. In fact, you'll recall that from the record that several commercial insurers were engaged with this process. And we went to them when we found out about this direct reimbursement scheme, and they all paid except Empire. So when Empire says there are no cases, it's true for both sides. What Empire has done instead is cited a bunch of cases, all with three things in common. Their cases involved the state Medicaid program, which is not involved here. Their cases involved a beneficiary or a patient who was eligible for Medicaid coverage, not involved here. And their cases involved an attempt for a provider from out of state to collect Medicaid dollars, which didn't occur here, and then go after a secondary source of payment, which did not occur here. Fourth, at the end of the day, there's only one thing that counts here, and that's a contract between Empire and Montefiore. And Empire admits that it is liable under that contract had the claim been submitted directly to Empire. There was some mention a moment ago about the standard contract, and I want to explain a little bit more about that because it supports what we're saying, that the Empire contract is what governs. The standard contract that was just referred to is the standard contract that New York State enters in with insurance companies when they wish to be licensed as Medicaid MCOs. The contract is found in the record at 117, or the citation to the state version of it is in page 21 of respondent's brief in footnote 7. What that state contract says to Medicaid MCOs like Affinity is this. It says, when you sign up hospitals or physicians, we want your provider agreement to say that they'll honor Medicaid laws, but only to the extent those laws relate to the furnishing of medical care. The state contract also says Medicaid laws don't apply to a private provider with an MCO contract with Affinity to the extent it matters to rates, fees, billing, and claiming, which is what we're talking about here. Submitting a claim to the proper insurer and getting paid for that. Since we're the last argument, and I'm sure everyone's anxious to go, I'm going to just make one last point about the prompt pay law issue that's raised. This was a motion to dismiss, and Empire is saying that on the motion to dismiss, it should be dismissed even though the standard is whether Empire had a good faith belief the claim was not payable. We've put in the complaint evidence of concealment, about a refusal to cooperate to identify the claims, about a refusal to even identify the entities that Empire engaged with this direct reimbursement scheme. On a motion to dismiss, we met that burden.
Thank you. Ms. Chapman, you have 2 minutes.
Thank you, Your Honor. 2 points. This point as to whether or not the Medicaid regulations apply to Medicaid MCOs, they clearly do. First, CMS has said as much. And second, the model contract between the state and a Medicaid MCO requires that the Medicaid MCOs include in their contracts with providers an explicit agreement to that effect. It also includes a specific reference to 515.2, one of the provisions that enshrines the payment in full requirement. So that is not an issue in this case. And second, to the issue of the precedent that we rely on, again, we've cited to multiple different cases that, while not on precisely the same facts that arise here.
Aren't those cases under a different factual footing? In most of those cases, it seems to me what's happening is that the hospital is trying to get a benefit. They've gotten the Medicaid payments and they want more. That's not the circumstance here. They have a private contract. They have a contract with a commercial insurer. They're just asking to be reimbursed pursuant to that contract. So those cases, at least to me, seem to be distinguishable.
So two things, Your Honor. First is that none of the payment in full regulations include a mens rea requirement. They don't ask why the provider is seeking this or why they waited to bill. And then two, I would point the court to Alliance Health.
But that's what the cases are looking at. The cases are looking at, for example, in the cases involving personal injury cases, and they're enforcing the regulations under those circumstances, the payment in full regulations. This case seems to be very different.
So, Your Honor, I would point the court to Alliance Health, which is a New Mexico intermediate appellate decision, and that also involved an instance where the payment in full requirement was interpreted for the benefit of a third-party insurer, and it involved a patient who was eligible or who should have been covered by the third-party insurance at the time that it was billed. That also involved a mistake, as we're talking about here. So I think that case really is one of the better cases for this proposition, that this is not just concerned with those very specific instances of balance billing. And I would also point the court to the fact that a number of these cases don't cabin their discussion as narrowly as the other side suggests. They talk about the— Thank you.
Time is up. Thank you so much. Have a good evening. This concludes the session of the Appellate Division, First Department.
Thank you.